mute. Good morning, everybody. The ICTJ is very glad to have invited you to this international seminar about the funding and the designing of the reparation work. So the goal is to bring together how to is the question.
To provide comparative knowledge that will guide Tunisian policymakers in order to bring ties between those in charge of countering corruption and to fund the Dignity Fund, to outline a map and provide the necessary information to be used by the state institutions and for the civil society and victims' organizations and representatives of the civil society to tap into these statistics to provide feedback about reparation policies.
Last but not least, providing general guidance on how reparation policy can be transformative as well as is responsive in an economy under austerity. I would like to invite, to thank everybody who has kindly accepted to take part in this seminar despite all the stumbling blocks. First of all, I would like to give the floor to Mr. Amrazak Kilani, who is the president of the Revolution Wounded and Martyrs. Thank you very much. First of all, I would like to extend my thanks to the ICTJ, headed by Mr. Fernando Tavesi, for the kind invitation. And I would like to extend my thanks to Mrs. Salwa Gantri, the director of the Tunis ICTJ. And I would like to congratulate her for her recent appointment as director of the ICTJ. The topic of your conference, as you have just stated, is how to design and to fund the reparation programs of the victims of tyranny. Honorable President of the ICTJ, ladies and gentlemen, honorable participants, as you all know, as you follow the process of transitional justice in Tunisia since 2011, as you know, the Truth and Dignity Commission has done a tremendous job to determine responsibilities, to unveil the causes and reasons of violations, and then made recommendations so to avoid the recurrence of the past violations, and to make sure that reconciliation, national reconciliation, does take place. And as you all know, 63,000 files from various political families and social strata have been examined by the Commission, and hearing sessions were organized for 43,000 people, victims of these violations. And but despite the stumbling blocks, despite the difficulties that we encountered, as you know, there are some political divisions, some political attractions which I witnessed, and which unfortunately still continue nowadays, nourished by some channeled media. And this led to the dissemination of the hatred speech against the victims themselves. However, despite all that, thanks to God, the Commission has succeeded and presented the results of its brainstorming to the Prime Ministry. And today, the challenge, the major challenge that we are facing is how to ensure the success of what we call the post-commission. And as you all know, Article 248 of the Constitution make it compulsory for the state to implement the system of transitional justice. And as you know, Article 11 of the Transitional Justice Law compels the state to repair or to provide reparation for the victims of a violation. And the state is responsible for providing, to provide the forms or the necessary forms of reparation in an effective and sufficient way for all victims. And the Tunisian constitution, as well as the organic law, obliges the three authorities to adhere to the finalizing of this process. I mean, the executive, the legislative, and judicial authorities. With regard to the executive authority, the Constitution and the organic law compels the President of the Republic, who is in his capacity of President, to provide what we call formal apologies to the victims of and this will constitute a clear sign to set the minds at ease and a sign to heal the wounds, and as well as a sign to share the feeling of the victims who had to bear the violation of the law since 1955. And as for the Prime Minister, he is, along with his government, they are the first people in charge of implementing the resolution of reparation system. Article 11 of the Transitional Justice Law and the law of 2011 stipulates that the state must provide all forms of reparation, enough and efficient reparation. This can be done through the implementation of the reparation measures implemented by the Commission through a global comprehensive program, and this is in accordance with the framework decision number 11 of the year 2018, dated 28th of May 2018, governing the determining of the criteria for reparation programs. And here we talk about, for example, the possibilities of the state and whether the state is capable to provide reparation for individuals on the one hand, and to provide reparation for the regions which were victims of the law violation, as clearly stipulated by the law of transitional justice. As for the government, and as you all know, it issued a decree in February 2018 clarifying the system or how to use the Dignity Fund, which is stipulated by Article 41 of the Transitional Justice Law, Organic Law. And you all know that since the issuing or the enacting of this government decree, which governs the use of the Fund of Dignity, the Commission, or rather the committee, which will manage this fund, has held only one single meeting in July 2020. And therefore, there are measures that must be decided in order to establish this fund. This includes the signing of agreements with the Minister of Finance and the Prime Ministry to determine the criteria and the conditions of using this fund. This has not been done yet. In addition to that, an important other issue is the issue is how to fund this fund, how to find the necessary financial resources. And as you know, this will be the topic of your seminar today. In addition to that, I have spoken about the executive authority and how to meet its legal commitment. As for the legislative authority, as you know, Article 8 of the of the law has set up specialized chambers, which will deal with the issues of violation. Specialized chambers to deal with these violations. And these chambers now are dealing with 99 files which it is examining. This includes 1,119 victims and 1,426 people who have allegedly committed the violations. As you know, in 2018, in May, the first file was the martyr Kamil al-Matmati. We are facing stumbling blocks about these sessions and the measures are taking too much time. There is also a certain slowness to deal with the files, and sometimes the hearing sessions have been stopped because of the lack or the non-presence of judges to deal with these files in these specialized chambers. And this slowness and this slow pace, of course, is only likely to lead to the feeling of failure and frustration among the victims' families. In addition to that, there is also the corona pandemic, which even cast a blow against the process, but at the same time, and here again I'm talking in my capacity of a lawyer, I consider that these long procedures, in addition to this long time-taking process, puts us in a situation which can be, in a way, a denial of justice. And this is for the victims as well as for the people who are alleged to have perpetrated violations. So the longer the period of time is, and as you know it has been quite long since the revolution, the process of transitional justice started. A ministry was set up, a Ministry of Transitional Justice and Human Rights was set up, and that ministry, Ratif, spent at least 3 years to draft the transitional justice framework law, and now we are at the judicial level, at the courts level, which will examine the violation to the alleged perpetrators and who will be sued for perpetrating these violations, and which will be sued by the specialist chambers. What can be said is that the alleged perpetrators, and according to some data that I received and which I witnessed, some were, like for example, police commanders, attended the sessions or the hearings. For instance, in the Barak Sahel case, we had three generals who were questioned by these chambers, and this is quite important, very important. Why? Because their presence, when they are summoned, will cast a certain credibility on the court cases and will facilitate the work of the specialized criminal chambers, and according to what was noticed, the victims were listened to, also the alleged perpetrators also were listened to during hearing sessions, and now we have reached the pleading level by both lawyers of the defendants, and this is as far as the judicial role is concerned. With regard to the third authority, which is the legislative authority, and as you all know, the government, according to Article 70 of the Transitional Justice Law, is obliged and compelled to provide a report which comprises its working plan in order to implement the recommendations and the suggestions presented by the Truth and Dignity Commission. And these recommendations have been forwarded to the government in July, last July, and according to Article 70 of the Framework Law of Transitional Justice, the government has or is compelled to provide a report within a year, and hopefully this will take place within the deadline prescribed. And during the preparation of this report, or once it will be presented to the Parliament, and the Parliament will examine and will monitor the implementation of this program and the measures which the government intended to take to avoid the recurrence of the past, of the violation of the past. So to summarize this process, the process of transitional justice, which is based on 3 pillars, which is truth, to knowing the truth, justice, reparation, and guarantees to avoid the recurrence of these past practices. I personally believe that the challenge that we are facing today, and which is faced by the Tunisian state, lies in the way or on how to provide reparation for the victims who already received decisions from the Truth and Dignity Commission. So this challenge, according to me, we must spare it all the political influences, because this is a big challenge for Tunisia. Big challenge is social peace, and the social peace cannot be achieved without national reconciliation, and this national reconciliation cannot occur without providing reparations for the victims of tyranny. And these victims have already obtained, most of them at least, have obtained decision about the need to provide reparations, and they have their own expectations. For them, the government, the state itself, has certain possibilities and resources and cannot fail them. And I personally believe that this raises another question, another issue, which summarizes the challenges faced by the government. It's like the government has now become the prisoner of an economic agenda, and the instructions provided by the monetary funds and World Banks, all for them asks for economic restrictions. In addition to this, there is unemployment, prevailing poverty, and consequently, how can the Tunisian state strike a balance between meeting all these requests while at the same time meet the instructions of, or the demands of the victims the victims who suffered from tyranny. And of course, this issue, of course, raises another question, which is the mobilization of funds for the reparation fund. And I firmly believe, and here I will speak bluntly and freely, I would like to state that the responsibility of mobilizing funds for the Dignity Fund is the duty and the responsibility of the former tyrannical systems, and had to be borne by as part of the international community. I don't want to mention their names, but I would say whoever supported the former regime, whoever funded the former regime, whoever was ready to provide this regime to quench the upheavals during the revolution of dignity, and freedom, I think that these international parties have to assume part of the responsibility of what happened to these victims, and therefore, and consequently, they must contribute to the funding of the Dignity and Reparation Fund, so that this experience, the Tunisian experience, as it is called, Tunisia, called the country of Arab Spring, as described by the West countries, Tunisia, which actually ignited the revolution of dignity. Tunisia now is on an open path, on the right track for the success of the democratic experience. It's an experience which we deem humbly unique in its category in the whole region, and consequently, I firmly believe that to turn the page of the past that we suffered from, which led to feelings of hatred among many Tunisian citizens, we must actually give people their rights, and we must also, and as you know, Tunisia has a strategical position in the Mediterranean Sea. As you know, it is a gate to Europe, and Tunisia can then play a leading role to prevent the whole region, to spare the region violence and extremism, terrorism, who spared nobody. And I thank you very much for your attention again. Thanks to the ICTJ I thank you too for your interest in the Tunisian experience, and I thank you for your kind invitation to hear me during this seminar, and thank you very much to everybody.
Thank you very much, Mr. Abdelrazak, for your presentation. I now give the floor to Mr. Fernando Trabelsi, the Executive Director of ICTJ.
Good morning, good afternoon, everybody. I hope everybody can hear me. On behalf of the International Center for Transitional Justice, ICTJ, I would like to welcome you to our international comparative workshop on how to fund and design reparation programs. I want to thank the German Foreign Affairs Ministry for its generous support to this activity and its strong support for ICTJ's work in Tunisia and elsewhere. And I also want to thank for their partnerships to the governments of Sweden, the Netherlands, and Luxembourg for their continuous support to ICTJ. I'm very pleased to be joined by the President of the General Authority for Resistance and the Martyrs and Wounded of the Revolution and Terrorist Operations, Lawyer Abdelrazak Hilani. I hope I said that well. And I wish him the best of luck in his new position. ICTJ has been active in Tunisia since 2011. Tirelessly accompanied all the transitional justice process related actors and remains committed to support their endeavors in the post-truth commission phase. The Tunisian state demonstrated commitment, goodwill, and responsibility with the passing of the transitional justice law and the establishment of the Truth and Dignity Commission and the specialized chambers. There is no transitional justice process in the world that is perfect or exempt of difficulties. The publication of the Truth and Dignity Commission's final report, while debatable in some respects, represents an important benchmark of the acknowledgement of the victims in the country. So is the starting of the legal proceedings in the specialized chambers. A lot, however, remains to be achieved, including the design of a plan to implement the Truth Commission recommendations, the publication of the list of wounded and martyrs of the revolution in the official gazette, the effective start and work of the Fund for the Dignity and Rehabilitation for Victims of Tyranny, and very, very importantly, the state's official apology to the victims. Despite what some tend to believe, transitional justice processes don't end nor are fully achieved when some of the institutions mandated to advance the cause of justice complete their terms. It is crucial to understand that the transitional justice process is not finished, and it is important to continue supporting a victim-centered transitional justice policy. Victims constitute an inspiration for the society and the state institutions. They demand acknowledgement, justice, and reforms, and they do not accept impunity or amnesty in the name of reconciliation. Comparative experience demonstrates that reconciliation cannot be solely obtained by delivering individual monetary reparation, which also do not guarantee by themselves the non-repetition of violations and abuse of power in the future. The guarantees of non-recurrence is an essential element of the transition if we want to ensure a democratic, inclusive society for the future generations. ICTJ has stood and stands by the side of all those individuals and institutions that pursue justice and accountability in Tunisia, including the Truth and Dignity Commission. We support and have supported TJ institutions here in Tunisia, but all over the world, grounded on our principles of neutrality and independence, always in adherence to international principles and the rights of victims, and with a critic and constructive approach. We are, however, acutely aware of how sensitive these processes are and how vulnerable they remain to political interference, how easily sometimes it is to divert resources and attention to other goals, which might be appearing as priorities, but ultimately compromise the efforts of fighting impunity. With the COVID-19 affecting the globe, it is important today to design development programs that take into account and are conducive to improving the respect of human rights and rule of law. Such has been for decades the pillars of the United Nations: human rights, development, and peace and security. The 75 years of the United Nations we are commemorating in 2020 have demonstrated us that those pillars are intertwined, that we cannot achieve one by forgetting the others. So the so-called choice between human rights and development is in fact a false dilemma. Reparations are sometimes presented pejoratively, arguing that their cost can compromise a fragile economy. However, well-designed and well-implemented reparations can greatly contribute in promoting economic development. Today, Tunisia has a chance to consolidate in its 5 years development plan the gains of the efforts made to recover national assets unlawfully transferred abroad, as well as with the implementation of reparation programs for the regions which were targeted by the authoritarian regime. It is important to outline the situation of victims in these regions. In these pandemic times, many victims do not have the possibility to access to healthcare, and they live in extremely fragile economic situation. A sound and well-designed reparations program combined with development strategies could help both the region and the individuals by implementing a strong health infrastructure that could facilitate access to COVID-19 vaccines when they are available. It is also important to make the international financial institutions, such as the World Bank and the International Monetary Fund, better aware of the responsibilities towards a country they help today and the impact of the decisions of the previous dictatorships they validated in the past. Reparation is an essential component of transitional justice and can actually contribute to enhancing the economy, strengthen development, and bridging between those marginalized areas and the center where decisions are taken. As we have seen in the sub-region, no transition is immune from setbacks and challenges. Tunisia has made enormous progress, has developed and promulgated a legislative and institutional transitional justice framework that would be hard to be dismantled. And it is fueled by the energy of the Tunisian civil society and institutions. The vitality and strength of civil society and victims groups in this country were and still are crucial to achieve progress. Even when they perceive their rights and expectations are frustrated, they continue demanding, advocating, and fighting for justice. And if they don't give up, neither can we. The victims' perseverance to achieve justice and their commitment to make of it a way to democracy is an inspiration for our collective work, which we must carry on, because we have a moral imperative to match their tenacity and believe that justice and democracy must and can be achieved. I thank you again for your kind attention, and I thank you all my ICTJ colleagues in Tunisia and elsewhere who has worked very much to put together this workshop. And I wish you a very successful workshop and a great discussion that can be implemented into action very soon in Tunisia. Thank you very much.
Thank you very much, Fernando. Thank you once again, Mr. Abdelrazak. We now move on to the first session on how to register and list reparation beneficiaries. What are the lessons learned from South Africa, the Philippines, and other countries? We hand over to Elena Norton, the expert and senior program advisor in the ICTJ, to run this session. There will be an open discussion following this session. And, of course, we will accept any comments from Facebook for those following this event. Thank you. You have the floor.
Good afternoon, and thanks to all of you. Let me just, Good afternoon. Sorry, I wasn't sure if I was on sound. So good afternoon, and thanks to all of you for joining us today. I just wanted to make reference very quickly to the report that's also mentioned in the agenda, because it will be of particular importance also to this first session that we'll be holding. The report is called Forms of Justice, and it's available on ICTJ's website in English, French, and Arabic. And it covers many of the same topics that we're going to be discussing in this first session. So first, I'd just like to introduce the panel for this discussion. First, Ms. Lina Sarmiento, who's the former chairperson of the Philippines Human Rights Violations Victims Claim Board, the independent quasi-judicial body that was mandated to receive and adjudicate applications for monetary reparations for human rights violations during the martial law period in the Philippines. Prior to her designation as chairperson, she served the Philippine National Police for almost 34 years in various fields of law enforcement, such as forensic sciences, operations management, drug enforcement, protective security, and police community relations. She played a key role in the organization of the National Police Human Rights Affairs Office and in the formulation of its Human Rights Comprehensive Plan. Also will be joining us is Mr. Howard Varney, who's a senior program advisor with ICTJ. He's now based in Berlin. His areas of expertise include truth-seeking, national prosecutions, institutional reform, reparations, and public interest litigation. Howard is a practicing advocate at the Johannesburg Bar. His legal practice includes human rights, constitutional and administrative law. In the early 1990s, he was an attorney with the Legal Resources Center in Durban, where he represented victims of political violence in public interest litigation, judicial inquests, and commissions of inquiry. In the mid-1990s, he led an independent criminal investigation in South Africa into organized political crime, which resulted in significant criminal trials. He's worked with the South African Truth and Reconciliation Commission as a consultant on a range of matters and was the chief investigator for Sierra Leone's Truth and Reconciliation Commission. He also assisted the Commission for Reception, Truth and Reconciliation in Timor-Leste with the compilation of its final report. As was already mentioned, during this first session, we'll be examining the question of how to register and list reparations beneficiaries by looking at experiences in primarily two countries, South Africa and the Philippines. I'm going to just make a reference here and now to just a few other countries, including Peru and Nepal, which are discussed at length in the report that I just mentioned. First, the task of conducting an accurate and efficient registration process and of creating a list of reparations beneficiaries is in some sense largely a bureaucratic and administrative task. As one would expect, these processes vary somewhat from country to country, given that the kinds of reparations may differ, as well as the available levels of state resources. Of course, much depends on what has already happened when the registration stage of the process is reached. Here in Tunisia, as already has been mentioned, you've already done many things necessary to registering and drawing up a unified list of victims, but more needs to be done. What we know from other countries' experiences, these efforts require a well-functioning bureaucracy with high levels of interministerial coordination, requires hardworking, reliable, and impartial administrators, and basic levels of information technology, banking, transportation, and communication systems. The checklist for both policymakers and administrators is long. During our discussion this afternoon, we'll be focusing on the mechanics of how victims' lists and registries were compiled in other countries to shed some light on the processes now underway at Tunisia's reparations agency, the Fund for Dignity. As you'll see from the agenda, Howard Varney is going to be looking in part at South Africa's experience with a closed victims list after its Truth and Reconciliation Commission concluded operations. And Chair Lena is going to discuss the point system that was used in the Philippines to calculate the amount eligible victims would receive in monetary reparations. That system is similar to what the Truth and Dignity Commission recommends for use here in Tunisia. Before the panelists start addressing those questions head on, I thought it would be helpful to just step back a moment to frame the topic we'll be discussing within the larger question of what is at stake. In Tunisia, as elsewhere, reparations registration processes and the creation of a unified list of victims bear similar to many other bureaucratic processes that are carried out by governments every single day. They involve the collection and recording of pertinent data and information, the filing and digitization of forms, and the engagement of civil servants, local governments, and others in these processes. However, although that is true, these registration processes that we're discussing here today, quite honestly, are not merely just another ordinary run-of-the-mill process for facilitating the filing of paperwork, as you well know. There's something quite distinct. They're a component of justice for the many victims who have suffered violations of human rights here in Tunisia. While accountability falls largely within the remit of the judicial and administrative commissions in Tunisia, reparative justice for victims falls within the remit of the Dignity Fund. As such, it will be the point of contact going forward now for victims. The information gathered about the violations they suffered, as we know, will often be quite sensitive. Those providing that information will often be vulnerable, and given the period and abuses covered, will likely include elderly, marginalized, many victims who are unwell. Of course, you've seen this before during the operations of the Truth and Dignity Commission, but it will have to be faced again. So a few words about how such implementing agencies have worked elsewhere to achieve a just outcome for victims. Although much information has already been gathered about victims, their families, and victim communities here in Tunisia, quite honestly, it's still necessary to register and perhaps re-register victims. Some victims may not have participated in the TDC, a reality that Howard will discuss next in the context of South Africa. Yet even if they have, victims' personal information will often need to be updated, sometimes for obvious reasons. A person's address, for instance, may have changed. Names will need to be confirmed or updated because of changes, for instance, in marital status. And family members who have not yet registered may need to register. In Argentina, for example, the application process for victims of arbitrary detention and enforced disappearance were reopened a number of times over the lifetime of the reparations programs there. This is not unusual. Reparations agencies like the Dignity Fund usually spend significant time and effort first registering and then building a reparations registry that lists the individuals, the families and communities who are eligible for reparations. Registration and re-registration are all part of the implementing process, something that registration authorities have done in many other countries. For instance, in Peru, after its Truth Commission ceased operations, a reparations council was established to register victims and to review and validate the existing registries or lists of victims that had already been compiled by different agencies within the government. It was an intensive process. Peru's Reparations Council conducted field work to reach victims not previously identified by the Truth Commission or other registries. This effort helped avoid dissatisfaction among victims groups and helped build up some of the trust that had sorely eroded over many years of conflict. To reach the most victims, the government in Peru signed agreements with churches, municipalities, regional governments, civil society organizations, and other institutions to provide assistance. It opened offices in the provinces most affected by the conflict. It also initiated an outreach process that included workshops and public gatherings with victims' organizations and community and indigenous leaders. Peru's Reparations Council created guidelines for obtaining the information needed to establish that a person was indeed a victim. Recognizing that not everyone had documentary proof, it accepted the testimony of community leaders and witnesses in support of victim applications. Hopefully, Chair Lena will have some time to tell you about similar processes that took place in the Philippines. In Peru, the registration process was ultimately far-reaching. To give you a sense of the scope of things, over the course of over 5 years, the Reparations Council in Peru registered over 160,000 individual victims and nearly 8,000 communities. All of this after truth-seeking had already occurred. An added benefit to these comprehensive registration processes is that they can help the authorities identify gaps in their programs. In Nepal, for example, over the course of a 4-year registration process for an interim relief program there, the entity tasked with collecting information from victims identified gaps, both in the beneficiaries and in the benefits. Orphans, for instance, had not been previously identified, and different populations of victims were receiving different benefit levels, which disadvantaged some. And as a result, changes had to be made to correct that, and they were. In other words, the process often encompasses some give and take, some adaptability. As in these other contexts, the success of Tunisia's reparations program will depend in part on that kind of give and take to ensure that the state is able to reach victims, record their demands for justice, register them, and then provide reparations in an effective and meaningful way. As the reparations section of the TDC's final report states, and I quote, "Reparations' importance in Tunisia stems from being the sole genuine path that focuses on victims. Ultimately, the amount of effort exerted now as the Dignity Fund is getting started and how victims are treated during this first stage in the process will reflect, quite honestly, on the overall process throughout. More fundamentally, it will impact on who is judged eligible, including who is identified as among those in need of urgent care or assistance now. Given that, how can the Dignity Fund ensure that the list of victims is inclusive and doesn't exclude or discriminate against categories or individual victims? Howard Varney will address this question in more depth during his discussion of open and closed lists in South Africa. Although it's important to keep in mind the prospect of receiving reparations should be an incentive for victims to come forward, as many did during the Truth and Dignity Commission. However, the process of registering the violation may also act as a disincentive. So in this process, all steps must be taken to guard against that, to avoid practicalities getting in the way of victims registering and participating. One immensely helpful step is to provide victims with assistance during this very process, at this very stage. I know there was significant effort put in to do that by the Truth and Dignity Commission, yet during this next stage, similar attention needs to be paid. There are surely many victims who are struggling economically or are facing other challenges in their daily lives that may be getting in the way of their participating. Those who are less educated may likewise be left out, and we all know that as COVID continues, that also may complicate matters. As such, poverty and marginalization should be taken into account when designing the registration processes to ensure that eligible victims can access reparations and that a unified list reflects those who actually were harmed. To remedy those disparities in Peru, for example, victims were supported by a state agency when filling out the actual application form. Someone actually sat down with the victims and helped them then locate documents they needed to verify their eligibility. To increase access, registration was conducted also by mobile teams of registrars who visited rural areas throughout the country to collect information. Much like the mobile teams that were already employed by the Truth and Dignity Commission. Although that arrangement will not work for all victims, it will work for many. In all these processes, fairness and the perception of fairness will be essential components for earning the trust of victims long term. If the institution responsible for managing the registry and creating a unified list is viewed as fair and independent, then the public is more likely to trust its processes as well. Second, as with other phases of transitional justice processes, well-conceived registration processes and initiatives should reflect the admonition to do no harm to victims and their families. This includes ensuring that no undue administrative and financial requirements are placed on victims. In Peru, at the beginning of the process, there was a trust deficit among victims. That deficit was overcome through careful coordination and outreach between and among the Reparations Council that was created, which was a standalone body, and other key stakeholders, including the staff from local municipalities, NGOs, including victims groups, churches, and other entities that made agreements with the council to reach hard-to-reach areas in the country. That process also took into account the fact that for many victims, it is painful to remember and narrate their experiences. To accommodate those needs, special psychosocial support measures were adopted during the registration process in Peru. The process of providing a statement at the Registry of Victims included a support component for victims that included listening spaces and psychosocial support provided before and after the testimony was given. Third, it helps to think institutionally and long-term. We know that reparations are but one part of a larger process of helping victims regain some trust in state institutions and of achieving justice. So it's surely essential to get pertinent information from victims necessary for the implementation process. The TDC has already facilitated that process during the collection of over 63,000 files. But there's another side to the coin. Registration processes can lay the foundation for the Dignity Fund and for other administrating agencies of the government to deliver the reparations once registration is concluded. Registration processes provide the government not only with victim data, they can inform the way that the reparations program itself is ultimately implemented. Finally, with that in mind, one last and quick comment. In other countries, registration processes can and have contributed to meet the broader reparative purpose that is at the heart of any registration effort. acknowledging victims, and addressing the harms they suffered. As Fernando mentioned, that's already been done in part by the Truth and Dignity Commission's report, but there's more to be done. As ICTJ has seen in other contexts, registration processes can themselves be made reparative. So the process of registering can be made reparative as well. All interactions between victims and the implementing agency, to the extent possible, should be an opportunity for acknowledging and reaffirming the dignity of victims who apply. To do that, symbolic gestures and measures of support have sometimes been integrated within the registration process itself. Let me give you just a very short example. For instance, the reparations form and accompanying guide used by the government has sometimes itself included statements acknowledging the victims and the harms they suffered. In Chile, the final list of victims' names, the registry, was itself a form of acknowledgement. That's what Fernando was making reference to when he was talking about the final publication of the list. In addition, as I've already mentioned, listening spaces and psychosocial support can be provided both before and after the registration processes are being undergone by victims. In some, reparation registration processes present both great potentialities and great challenges. I hope this overview just gives you a sense at least of some of what's at stake here. And now to address some of those challenges in greater depth, I would like to turn the table over to Howard Varney, who will focus on, as I mentioned, South Africa.
Ellen, thanks so much for that incredibly helpful background. That really gives great context to the case studies that are going to follow. I hope that I'm loud and clear. And to my friends and colleagues in Tunisia, salam alaikum. My apologies that we're unable to be with you in Tunis this afternoon. Hopefully, when we get the pandemic under control, we'll be able to meet with you again, hopefully in 2021. So I've been asked to talk about South Africa's closed list policy. I have prepared a presentation which I'd like to put up on the screen. Is the presentation on the screen? Eleanor, if it's there, perhaps you can just let me know.
I can see it.
Great. Then I'm going to.
Yes, it is.
I'm going to assume that it's on the screen for everybody. So South Africa is often seen as something of the gold standard when it comes to transitional justice. And we have to thank the Truth and Reconciliation Commission for that reputation. However, if we look at what has transpired in South Africa post the winding up of the Truth Commission, it is something of a sorry story. In fact, South Africa has fallen somewhat short when it comes to caring for victims. So while it might be seen as a model for transitional justice when it comes to a negotiated transition, when it comes to interrogating the past, it can hardly be put up as a model when it comes to dealing with redress, and in particular, the question of reparations. Indeed, I think it's true to say that the South African authorities, the successive governments, post the TRC, have turned their collective backs on victims. In fact, some would argue they have taken a decision not to invest in those who have made the sacrifices for the liberation of South Africa. And needless to say, tens of thousands of victims have a sense of betrayal. But turning to the topic for discussion, before we get to the closed list policy, I would just like to place the process in South Africa in some context. And to do that, I'd like to look at certain passages emerging from certain legal texts, starting with the 1993 interim constitution. In the postscript to that constitution, which really set down the ground rules for our transition, it also set out the path for the future. And when it came to the question of redress and accountability, the postscript came up with some resonating and poetic words, and I quote an extract. The postscript said that the legacy of past hate and fear can now be addressed on the basis that there is a need for understanding but not vengeance, a need for reparation but not for retaliation, a need for Ubuntu or community but not for victimization. So right from the outset, we understood the moral imperative for reparation. And indeed, it can be argued that since those words appeared in the interim constitution, there was also a legal obligation to provide reparations. And that was then recognized in the 1996 constitution, our final constitution, and the preamble there required South Africa to recognize injustices from the past, to honor those who had suffered for justice and freedom, but also to commit to healing the divisions of the past, and establish a society based on social justice. And we would argue that we can interpret the preamble to include an obligation for redress. And this ultimately then resulted in the Promotion of National and Reconciliation Act, which set up the Truth Commission. And the objects of that act included implementing measures that were aimed at granting reparation and rehabilitation and restoring human and civil dignity. And for that purpose, a victim was defined as anybody who suffered harm as a result of a gross violation of human rights. So, for example, where families lost loved ones, persons who were murdered or disappeared, that would constitute a gross human rights violation perpetrated on that family. And there were several other violations as well, including torture, forced displacement, and several others. So unlike Tunisia, where there was a legal obligation to implement the reparation recommendations of the Truth and Dignity Commission, in South Africa there was only a general, moral, and legal obligation to do something, but there was no legal obligation to follow through with the actual recommendations of the Truth Commission, and indeed they were largely ignored. So where did this closed list policy come from? I'm sorry to disclose this, but in fact it comes from the Truth Commission itself. And in the Truth Commission's 1998 report, it in fact adopted what it referred to as a closed list policy. In other words, reparations, those qualifying for reparations will be limited to those who had made statements to the Commission before the so-called cutoff date of December 15, 1997. And of those persons, it would then be further confined to those who were in fact declared victims following a verification process. Now, the cutoff date was something of a practical measure that had to be taken because the Commission was winding up its two-year mandate and indeed had to issue its report the following year. The justification for this closed list policy was, in the Commission's words, not to unduly burden government. They felt that they somehow had a responsibility to limit the burden placed on government in taking care of victims. They did say that this was a painful decision and they would like to have taken more statements, but since they simply had to wind up and close the Commission, they were not able to do so. Now, I have to say that although one has immense respect for people like the Chair, Archbishop Desmond Tutu, as well as the commissioners, to suggest that they were going to limit the burden on government for purposes of assisting government and protecting the national fiscus is something of a monumental blunder on the part of the Truth Commission. It was certainly not within their remit to take care of government. They were under an obligation to ensure that all those who had suffered these kinds of violations were given a reasonable possibility of coming forward and being recognized as victims, and where they were unable to do so, to make the necessary recommendations to ensure that those victims were accommodated going forward. And yet we see a statement made by the Commission suggesting that it was entirely justifiable for government to simply close the door after December 15, 1997. And indeed, the Commission notes that in the days and months following that date in December of 97, hundreds came forward to the Truth Commission and had to be turned away. And indeed, in the years following, victim groups recorded another 8,000 statements. So by the time the Commission ultimately closed its doors, the amnesty process carried on through till 2002. And by the time they issued their final amnesty report in that year, victim groups had already recorded another 8,000 statements. And we will see that that number has expanded over the years. Nonetheless, the Commission did come to the conclusion in 2002 that the list, the so-called closed list, is not intended to be exhaustive of all those who may be defined as victims of apartheid. So unfortunately, the Commission ended up contradicting itself in the same report. So the statement-taking program was the method by which the list was generated. And so the Commission received a little over 20,000 statements, and around 19,000 were found to be victims of gross human rights violations. But the Commission noted that it itself was under considerable restraint, and that not only was it unable to take all the statements it wanted to, but it wasn't even in a position to properly investigate the stories in each and every statement. And so it's indeed possible that many of those who did make statements couldn't have their cases properly considered and may not have been declared victims. By 2009, the leading victims group in South Africa, the Kulamani Victims Support Group, noted that it had recorded nearly 45,000 people who had complained of gross human rights violations and had been listed as victims in the Kulamani victims database. And today that number is just under 100,000 victims. So we have seen that civil society have in fact continued to record victims. So even though the Truth Commission only took around 20,000 statements, and they recognize that those 20,000 statements disclosed the existence of around 50,000 potential victims, but over the years, up to the present date, Kulamani, through its offices around the country and its efforts engaging in outreach, have collected statements from around 100,000 people they believe would have qualified as victims under the Truth Commission law, namely individuals who have suffered or experienced gross human rights violations. And in fact, they have put together what they claim to be a very credible database. They have their own statement-taking forms, and they have offered these resources to the state. They've come up with an interesting breakdown of the kinds of gross human rights violations experienced by victims. And you'll see the biggest group of around 41% experience indiscriminate shootings. The next biggest group involved extrajudicial killings. Then the others involving torture and inhumane treatment. And then the fourth biggest group is that of prolonged arbitrary detention, and then the various other groups as well. But as mentioned, the statement-taking program experienced many shortcomings. For starters, it only ran for approximately 20 months, which is an incredibly short period, given the number of potential victims. At a practical level, even though there were approximately 6 officers around the country, many victims were simply not in a position to get to an office. The Commission understood this, and they, with the support of civil society organizations, they did organize several mobile teams who did try to penetrate outlying regions, rural areas, small villages, and towns. But in many respects, this was a haphazard program, and many people simply didn't even know that the Commission teams were in their areas, and by the time they got to learn about the program, those teams had moved on. Then there were others who were simply too afraid to come forward. There were others who had political constraints in the sense that certain political parties were opposed to the Truth Commission and actually instructed their members not to engage with the Truth Commission. Many victims still suffered from post-traumatic stress and were not in a position to express themselves. This applied for those who were in solitary confinement and who had been tortured, those suffering from mental and physical disabilities. And because they were not able to make a statement, they did not end up on the victims list. As matters stand, they have been denied reparations forever. Another example is that women are terribly unrepresented in the statements. So more than 3/4 of women's testimonies, as well as 88% of men's testimonies, related to abuses in relation to men. And only 17% of women's testimonies and only 5% of men's testimonies related to abuses dealing with women. And the balance dealt with both women and men. Sexual abuses were rarely discussed in the statements and in the interviews. So we now know that women, as well as crimes committed against them, were horribly underreported. So this is a good example as to why an ongoing registration process was needed in South Africa. I mentioned in the 2002 Truth Commission report, the report that dealt with the amnesty program. At that point in time, the commissioners realized that they had blundered in recommending a closed list policy. And at that point in time, they warned that excluding so many victims will promote divisions in society. And they then called on government to revisit the closed list policy and to review it in order to ensure justice and equity. And indeed, they started to point to experiences in other countries. So, for example, the Valek Commission in Chile eventually realized that they had neglected underage victims. And so years down the road, they reopened the application process to ensure that children and youth were not left out of the process. And as Eleanor has already explained, several other countries post the Truth Commission, examples come from Argentina, Chile, Peru, Guatemala, and Sierra Leone, carried on with a registration program. And in most of those countries, the post-Truth Commission registration tended to exceed the numbers of victims registered through the Truth Commission itself. And in Colombia, the window for registration was a 10-year period. So we see that limiting a registration period to the life of the Truth Commission And in South Africa, in fact, even though the Truth Commission ran for a period of 2 years, the statement-taking program only lasted for around 18 to 20 months, which really limited what could be done in such a short period of time. So what was the response of the South African government? It was simply to adopt the closed list policy and refuse to budge from that approach. When South Africa developed its reparations program, it did not involve civil society. It rejected civil society demands for ongoing registration. As a representative of victim groups, I've been involved in meetings with the Minister of Justice, and I've also assisted them in making submissions to parliamentary portfolio committees. And the response of officials is, well, in fact, all Black South Africans are victims. So why should we single out a small group for special treatment? They simply have failed to grasp that those who suffered harm need special redress. And that's reflected in the approach of the South African government. They rejected a very modest proposal by the Truth Commission, which called for a 6-year period of annual individual grants, as well as specific health, educational, and other tangible support. And they simply went ahead with a once-off pro rata payment of 30,000 rands to individuals on that closed list. At the time, that amount amounted to little more than $5,000. And they only managed to trace 16,000 on that closed list. So in fact, the reach of the South African reparations program has been minuscule. Regulations have been published for education and healthcare support. And so far, they've only managed to get the education program off the ground. And again, this is only in relation to individuals on the closed list as well as their families. So victim groups have objected to the closed list program on a number of grounds: procedural, constitutional, and international law grounds. They've argued that excluding victims from the conceptualization of the reparations program has been a violation of their rights to dignity. The closed list policy in itself violates the Truth Commission Act, because the Act classified a victim as somebody who has experienced a gross human rights violation, which then demanded that there be put in place a program that would allow individuals the time and space to come forward. It violates both the interim and final constitutions, because both those constitutions called on South Africa to take the necessary steps to heal the divisions of the past and promote social justice. It amounts to unequal treatment and unfair discrimination because it only assists those on the closed list, only those who happen to be lucky enough to be able to make a statement before the cutoff date. It therefore violates a number of entrenched rights, including the right to human dignity. Needless to say, it violates South Africa's obligations under international law, because it denies those not on the closed list a right to an effective remedy, which is protected by several treaties ratified by South Africa. And then finally, I'd like to just contrast South Africa's treatment of victims and perpetrators. The South African Constitutional Court, as well as government spokespersons, viewed reparations as something of a quid pro quo. It was a means of alternative redress. So the victims had to accept that perpetrators would have an opportunity to apply for amnesty if they disclosed the full truth. And if amnesty was awarded, not only would there be no criminal liability, but victims also would be denied the opportunity of claiming civil damages for any losses they had sustained. And yet, perpetrators, the government has bent over backwards to accommodate perpetrators. They extended the cutoff date for the political offences period to include political offences conducted in the early 1990s, well after the negotiations had commenced. And not only that, when it was clear that the amnesty process would not meet its deadlines, the amnesty program was extended by another 5 years. It carried on working even after the Truth Commission had closed its doors to ensure that all perpetrators would be given an adequate opportunity to have their applications properly processed and heard and decided. And yet no consideration was given to extending the life of the statement-taking program or of instituting an ongoing registration program, which could easily have been done, given that South Africa, like most countries, have well-oiled departments dealing with social services and social welfare. And we could have simply piggybacked the registration program on the back of existing government facilities and systems. So there really ought to have been an appropriate balance struck between benefits afforded to perpetrators and victims. And in South Africa, I'm sorry to say that we did not strike that balance. And in fact, we have accommodated perpetrators at the expense of victims. Now, the Office of the High Commissioner of Human Rights has indicated that imposing restrictive application deadlines is not only unrealistic, but can be harmful. They've noted that this can have a terribly disproportionate impact on the marginalized, on women and girls, and of course, those who are historically excluded from political processes. And we've seen that in South Africa. One would have thought that the victim constituency would have been a constituency that would have some clout with government, and yet they simply haven't had the clout to persuade a government to come to its senses. This has forced them to take astonishing steps, and one of those steps was to seek reparations from multinational corporations who had collaborated with the apartheid state and aided and abetted in the apartheid state's systems to repress Black South Africans. And so over the years, several claims for compensation have been levied against big corporations such as IBM, GM, Ford, Daimler, and others. So far, that litigation has sadly not been successful. A small settlement has been secured from General Motors. And we have seen the South African government actually climbing into bed with these corporations to oppose the claim for apartheid reparations from these multinationals. And this has left victim groups such as Kilimani to have to engage in extensive campaigning and lobbying. And this slide demonstrates some of the campaigns that they've launched over the years, including a campaign which involves red carding government. And they have camps in the offices of the Ministry of Justice and other government officers to red card those individuals for turning their backs on victims. And even just last week, we saw families and victims demonstrating, calling for redress, calling for outstanding reparations. And so this picture depicts a group of Kilimani support group members protesting outside the union buildings in Pretoria, demanding reparations some 20 years after the winding up of the Truth Commission. So South Africa really is an example that ought not to be followed. And we should rather be looking at countries that have adopted a more compassionate and humane approach to the question of registration of victims. And thank you for your patience. That's where I'll stop.
Yes, I guess we, Chair Luna, would you like to begin your remarks?
How do I unmute? Okay.
Yeah, I think you have it.
Okay. Good day to everyone. It's 8:32 p.m. here in the Philippines. May I be allowed to share my slides? Yeah.
Yes.
Okay. Yeah, it's been 2 years, more than 2 years since I was with the board. I am now Deputy Director General of the Technical Education and Skills Development Authority. Provides vocational and technical training to Filipinos. So I've been here since December, doing something which is different from what I did 2.5 years ago. So as a brief backgrounder, the Philippines passed Republic Act 10368, otherwise known as the Human Rights Reparation and Recognition Act of 2013. It's an unprecedented act of the Philippine state, which recognizes the heroism and sacrifices of all Filipino human rights violations victims during the martial law period from 21 September 1972 to 25 February 1986. The law was enacted on February 25, 2013, but it was only on February 2014 when the members of the board were appointed and the board was organized. I was still then with the Philippine National Police, and I had to optionally retire to chair the board. So the Human Rights Victims Claims Board was an independent quasi-judicial body. It was attached but not under the Philippine Commission on Human Rights. The board is composed of 9 members divided into 3 divisions working simultaneously and independently. Under the law, there are 3 key deliverables: the monetary reparation, non-monetary reparation, and the role of victims for the Memorial Museum. I just would like to go through the claims process. This is based on the provision of the law, although we did some enhancement using technologies so as to lighten the workload of all the members of the board and the staff. So we start, the process starts by the preparation by the victim or claimant of the documents, which includes an application form, which we designed immediately after we were organized. The documents that they have to attach is an affidavit narrating what happened to them during the martial law period, and supporting documents to as evidence of their claim and their stories. And then these documents are submitted to the board secretariat, which conducts pre-evaluation as to the completeness. So what the Secretariat does is just to pre-evaluate the documents, whether they are complete, and then the applicants or the claimants were documented by taking their photographs and their signatures, and these signatures are digitized, and it formed part of a receipt that we issued to the claimants, which they used when they claimed the reparation after adjudicating the claims. So we release an acknowledgement receipt that contains the photograph of the person and their signature together with the docket number of the claim. And then we proceed to the evaluation and resolution of its claim by the board. When I say the board, it pertains to the 3 divisions of the board working independently and simultaneously. And then after the issuance of a resolution approving or denying the claim, then we published the preliminary list of eligible claimants in the 2 newspapers of general circulation. That is also a provision of the law. And then we wait for the filing of opposition or appeal. So those who have pieces of evidence that will negate what was presented by the claimant can file an opposition. And those who were denied can also file an appeal. Not only those denied, but also those who are not satisfied with the number of points that were awarded to them, they also filed an appeal. And then these oppositions and appeals were decided by the board and bank. And then after the resolution of the oppositions and the appeals, then we again published the final list of eligible claimants. And that's the only time we were able to determine the monetary award for eligible claimant. And then we distributed the monetary award, which should be claimed personally by the victim or the claimant. This is also a provision of the law. So there were so many challenges with regards to distribution of the monetary award. Okay, so we did our intake operations for a period of initially 6 months, but then it was extended to another 4 months. So from 2014, for the first 6 months, we received 47,128 claims. We initially thought that we will only receive around 20,000, which is around double the number of persons or claimants in the Hawaii claims. Because for the information of everyone, the human rights violations victims in the Philippines filed a class suit in the Hawaii court, and around 7,000 to 9,000 of them were approved. So we initially targeted a total of 20,000 claimants, but we received 47,128. And then in 2015, during the extension, we received an additional 28,621. So we received a total of 75,749 claims. So these are photos taken during our intake operations. Even if we are only very few in the board, because we started from almost scratch. We have no one except ourselves. We have no office. We have nothing. So we really started from scratch. That's the challenge that we encountered. While we were only appointed in mid-February, we started our intake operations on May 12 of 2014. So these are photographs taken during our caravans. We went around the country so that we will be more accessible to the claimants. It would be very difficult for the aging claimants to go to Manila to file their claims. So we went around the Philippines to receive the claims of the human rights violations victims. So these are just some of the photos taken during the intake operations. We explain what the law is about, and then we brief them on the different violations that can be eligible for reparation, and the point system. Point system was also explained to the claimants before the acceptance of their application. So we always start with a short lecture about the law and the highlights or the salient features of the law. And then we also entertain their questions. Okay, so after adjudication, the board approved the final list of 11,103 human rights violations victims. So these are the violations under the law: enforced disappearance and killing, 10 points. So around 21% for torture, around 19% for arbitrary detention, 30%, and other analogous violations, around 30%. So I would now proceed to how we implemented the point system. We initially started by formulating the guidelines and parameters of the point system. We created a committee on standards composed of, there are lawyers in the board, and we also have we have 2 doctors in the board, and then we also have victims of human rights violation during the martial law period. So what we initially did was to create a committee on standards, which drafted the guidelines and parameters of the point system. This is very important because there are 3 divisions of the board. And the uniformity in the appreciation of the claims is very important because the 3 divisions of the board work simultaneously and independently. So we really have to identify or to have a very specific description of every point. And then we apply the points. And that is really very, very challenging for us, even if we already prepared a very comprehensive guidelines on the point system. It's still very difficult to implement and apply. So for your information, under the law, these are the points. So if it's killing of persons while they are exercising their civil and political rights, involuntary disappearance, still missing as defined in RA 10353, which is the enforced disappearance law. So that will be given 10 points. So this is one area of contention. When do you exercise civil and political rights? And then for torture and or rape or sexual abuse, it's 6 to 9 points. So when do we give? When do we give 6? When do we give 7? When do we give 8? And when do we give 9? So this is where we were able to base the assignment of points on the guidelines that we formulated. So for every point, we have a description. When do we give 6? When do we give 7? And so on. And then detention without a valid warrant of arrest issued by a civilian court. So there's, again, 3 points, 3 kinds of points. So 3 points, 4 points, and 5 points. So when do we give 3? When do we give 4? And when do we give 5? So that's also very specifically described in our guidelines. And then force or intimidation causing involuntary exile from the Philippines, it's 1 to 2 points. So that's again, when is 1, when is 2. Force intimidation or deceit causing unjust or illegal takeover of business, confiscation of property, deprivation of livelihood. So 1 to 2 points. And then kidnapping or otherwise exploiting children or persons suspected of committing acts against the Marcos regime, and sexual offenses against human rights victims who are detained. So that's again 1 to 2 points. So this is where we had difficulty. When do we give 1 and when do we give 2, even with the guidelines. Okay, so what are the challenges in our work during the adjudication of the claims? Of course, one major challenge, not just the point system, one major challenge is how to accommodate all the claimants. The office is very new with only very few people, with very few equipment. So we had to rely on technology. It's very good that we were able to have our own information system where we were able to encode and digitize all the documents, and it helped us a lot. But even with the use of technology, we still had a difficulty in adjudicating all the claims because of the sheer number of the claims. So what are the challenges? The first is formulation of standards per points. It took us a while before we were able to finalize the standards, because it's really very tedious, and it's there are different contradicting opinions, but we were able to hurdle that, and we were able to have the guidelines that became the basis for during the adjudication of the claims. And then there are human rights violations victims that felt offended by the assignment of points. They were telling us that the sufferings that they experienced were the human suffering is immeasurable, and it's very offensive for them to be assigned points. So they were expressing their thoughts and their feelings to us. And then another challenge is that there are some claimants that were tempted to submit fake documents for higher points. And we because of the use of technology, we were able to identify easily contradicting statements coming from the same claimants, because some of the claimants acted as witnesses to their friends or relatives, but when we compared their statement with their other statement as witness, then they tend to contradict. So we felt really bad, because why would they do this? And then of course for fixed reparation fund, because we have a fixed amount of money, and that is 10 billion pesos. We need to complete the adjudication of all claims before we can distribute the reparation. So that's the only time we will know the value of 1 point, after completing all the adjudication of all the claims. So it took us a while, and we had to finish. And aside from that, our law has a sunset clause that says that within 2 years, which was extended for another 2 years, that the board will automatically cease to exist. Okay, so what are the recommendations of the board? on the point system, because I was told I'll be discussing about the point system. So under the final report, based on the final report of the board, we recommended that there should be a fixed amount for every offense, because it delayed the delivery or the distribution of the reparations. So aside from the fixed amount for every offense, there should be a regular schedule of payment. Because some of those that filed the claims were not able to receive the reparations because of their age. They were not, some of them can no longer go to our office to receive the reparation, and some of them already died before we were able to distribute the reparations to them. So we were hoping that if under the law there was a fixed amount for every offense, some of them, those who died, would be able to at least receive their reparations personally. So this is all for me, unless there are questions. There are, of course, several other challenges that we encountered in the adjudication of the claims, because we wrote decisions for each and every claim. So if that's 75,000 claims, we wrote decisions for each one, whether they are denied or they are approved. We wrote decisions. And when we say decision, the decision is a complete decision with all the facts and the pieces of evidence that they submitted, and the reason for approval or for the denial of the claim. So thank you very much for inviting me to this discussion. Nice to meet all of you. Thank you.
Well, thank you so very much, Lena, for that presentation. There are a few questions that I would like to pass along. Howard, there's a question that's been directed to you, which is, how can Tunisian civil society, can you cite some examples of good practices from other countries that could help win over the government's resistance to recognizing truth, reparations, and accountability?
Shall I deal with that now, Eleanor?
That's what I was suggesting. The questions are coming in a little at a time, so I thought maybe we just see as more coming in. So that's the first one.
Okay. Yes, in fact, there are considerable examples of civil society taking concerted action. In fact, in my own country, South Africa, I think the work of victim groups, in particular the leading group, Kilimani Support Group, is certainly worth looking at. Even though they don't have much to show for themselves in terms of tangible benefits, they have kept the issue alive over more than 20 years through a range of activities, including consistent lobbying, publication of research studies, making of documentaries, and of course, civil action, as in protest actions, as you've seen in my slideshow. So that's certainly an example of what can be done to ensure that the issue isn't suppressed. However, all that activity has not persuaded government. So much more is needed, and I think civil society have to look at other measures beyond these kind of high-profile activities, and this may include litigation in the courts. This is easier said than done, although I think we have seen some good examples from the Philippines and elsewhere. Perhaps Lena can also talk about how court cases in the Philippines have played a constructive role. In South Africa, we have struggled to get consistent instructions when it comes to litigation. Not entirely clear to me why we have been struggling to put these cases together. On the question of accountability, we have achieved more success. But on the question of reparations, we've actually seen victim groups unable to come to agreement, for example, on identifying individuals to become applicants in cases, as well as in disclosing databases for purposes of class actions. It does point to a weakness in organized civil society at this level. So there's certainly much that can be done, and I would certainly recommend parallel activities. On the one hand, one does need to take the kinds of actions we've seen in South Africa to expose the shortcomings in government. But at some point when this falls short, then more concerted action is required, which may involve public interest litigation, although that takes considerable organization and the reaching of consensus amongst these organizations. Finally, I would recommend that civil society organizations take steps to persuade policymakers, which means persuading political role players. And surprisingly, in my country, victim groups have been singularly unsuccessful in persuading political parties to climb on board and take ownership of this issue. It is surprising given that some of the political parties, indeed the ruling party, would traditionally see this group as their constituency. But certainly without persuading the political factions that this is necessary, one will always struggle to have an impact on policy.
Thank you so much, Howard. There were a few comments, just general remarks that I just like to raise so that we can think on them. Bashir Buchiba has expressed some frustration at the fact that the files of the victims has taken 10 years and there have been no reparations during that period, and is eager, of course, to have implementation of the recommendations of the Truth Commission. I'm going to join that together with a question about how in Tunisia victims can be reached in all the regions. I think this would be the beginning of a start to that failing of the process to date. So Lena, I'd like to direct this question to you. This is now that the fund's management has started its work, and of course it will need to be reaching victims, and because in the Philippines an extensive outreach campaign was undertaken. If you can just address, as you mentioned, that there were many elderly victims given the great distance in time between when the reparations program was begun and that period when the abuses occurred. If you can just talk a little bit about what kinds of steps were taken in addition for outreach, not in terms of informational steps that you took during that process. I think that might be helpful.
Okay, before we started accepting the claims, we had an advocacy plan. It's some kind of a communications plan on how to reach the target audience, and of course those are the claimants, the elderly, because most of them are in their 60s and in their 70s. So we had posters As a matter of fact, the Embassy of Switzerland in Manila helped us produce the posters. And then we partnered with the media to help us in disseminating the information. And of course, one important group that really helped us are the human rights organizations themselves. Because here in the Philippines, the human rights violations victims are very organized. One reason for that is because they already filed a class suit in Hawaii, so there is already an organization. They call themselves Claimants 1081. And then there are other human rights organizations that help us disseminate the information to all their members. So whenever we go to a certain city or a certain place where there are many expected claimants, we already have we already disseminated the information before we go there. That's the reason why, if you look at the photos, there are a lot of claimants coming. But even if there are many claimants who came during our caravans, there are still others who were not able to file. So that's the reason why we went back to those places, and it even included additional locations so that we can reach as many claimants as possible. The only problem with our law is that the claim should be filed personally, and the reparations should be received personally. So it's so difficult. There are cases when the victim is very sick and cannot come to us to get the reparations, and we had to go to the house to bring the reparations to them. So that's the one thing that we were not able to address, because it's specifically provided under the law that the reparations should be received personally by the victim. But for those who already died, what happened was there was an amendment of the law extending the life of the checks, and also allowed legitimate heirs to claim the checks. So when this happened, the board has already ceased to exist, and it was the Commission on Human Rights that helped some members of the staff of the board to distribute the checks to those claimants who were not able to claim during the 4-year period of the existence of the board. But we also on top of that, I forgot to mention, we also established regional desks. When we went around and had our caravans, we felt that we cannot leave because there are still other claimants who might want to file. So we decided, I think that was 4 or 5 months into our existence, we decided that we need to have a desk in every region of the country. So it's a 1 or 2 person desk that we placed in the offices of the Commission on Human Rights in every region of the country that received the claims. And then it was forwarded to our office, and we encoded and digitized the documents, and that's it. Another help came from the local governments. We reach out to the local government organizations. Every time they have a meeting, the National Organization of Mayors and Governors, I volunteered to present the provisions of the law and how they can help. So something like that. We reach out to whatever available partner that we can get to help us disseminate the information.
I've been told that there'll be questions from the conference room itself. So I'll turn that over there. I can't see, I don't see anyone at the microphone, but.
Thank you very much. I have a question I'd like to address to Mr. Howard with regard to closed list. If you can shed more light on this, who determines this closed list, whether it is the government or the commission or committee? With regard to the reparations, you said that they vary between 30,000 rand and 16,000 rand. What would be that in euros or in dollars, so that I can understand the value of the reparations given, and to understand whether the reparations were good, substantial or not. I have another question with regard to recovering the land that have been seized by the apartheid. Have all these lands and farms been recovered and given back to their owners or not? And last question, what is the situation of the victims today in South Africa? If you can shed more light on that, I thank you very much for your attention.
So thank you for those questions. Dealing with the first question, the closed list. So the closed list was actually an idea that was put on the table by the Truth Commission itself. And as I mentioned, the Truth Commission attempted to justify the closed list in an ill-considered endeavor to protect government and to not place a very heavy burden on the state. I think most Truth Commissioners now looking back will accept that that was a terrible blunder and mistake on their part. That was set out in the 1998 final report. But in the report that accompanied the winding up of the Amnesty Committee, they realized that that was a mistake, and they called on government to review the closed list policy. The closed list policy was simply a decision that those who were currently on the list of victims developed by the Truth Commission, in other words, those who had made statements and had been declared victims, in Chapter 7 of the report, they actually published the victims in a long list. Nearly 19,000 individuals were on that list, and that was the so-called closed list. Unfortunately, the government then adopted the closed list policy, and as far as they're concerned, the only victims of apartheid-era violations in South Africa are those individuals whose names are on that closed list. And all attempts by victim organizations to persuade them to abandon the closed list and engage in an ongoing registration have fallen on deaf ears. I have advised victim groups that they should challenge this policy in the courts, although I'm still waiting for those instructions to be given to me before I can proceed. When it comes to the actual reparations awarded by government, they decided to reject the 6-year annual payments. The Commission had recommended a range of reparations, but really quite modest reparations, only $3,000 a year to victims over a 6-year period. together with other tangible support by way of educational and healthcare benefits. But in the end, the government decided to do what they regarded as a clean approach by simply awarding a once-off pro-rata payment, the same payment to everybody, regardless of the harm and suffering sustained by victims. So they didn't adopt a point system as we've seen in the Philippines. There was no attempt to assess the actual harm suffered. If somebody had simply been slapped around by the police in detention, as opposed to another person who may have been terribly tortured and disabled, or perhaps lost all ability to sustain a livelihood, or somebody else whose parents had been abducted and disappeared, everybody was simply given the same payment once off of 30,000 rands. And you ask, well, what is that in perhaps dollars or euros? At that time, it would have translated into about 5,000 US dollars. And it was only awarded to 16,000 individuals because they can only trace 16,000 victims on that closed list. So in fact, the amount of payments made in South Africa is a real drop in the ocean. Kulamani, as I mentioned, have developed a database that has more than 100,000 victims. And they believe that the government simply has to raise in the region of $2 billion a year over a 10-year period. Sorry, not $2 billion, 2 billion rands. And in today's money, that actually doesn't amount to a huge amount in US dollar terms. It's around perhaps 70 million US dollars a year over that period. And even though South Africa is a developing country, that is a sum that is certainly affordable if the political will was there. Turning to your next question, a good question dealing with the question of land restitution. It's a topic that is a burning issue in South Africa. And in fact, historically, at the turn of the 20th century, the colonial powers decided to restrict black land ownership to only 13% of the land. And indeed, over years, that was reduced even further. It was decided to set up a land restitution program by setting up a land claims commission together with a land claims court to deal with land claims on a case-by-case basis. And on paper, it appears quite a good program and quite a fair program. In practice, though, it's turned out to be quite unsuccessful. And that is because land claimants have to demonstrate title to land. And of course, when a title goes back 100 or more years, it's often quite difficult to find that paperwork or to demonstrate otherwise legal title. And so the process has been desperately slow, so much so that some people in South Africa are advocating a Zimbabwean-type approach of simply settling on land and claiming that land for themselves. And in fact, in some parts of the country, that has happened, which has resulted in police action. So the land question still has to be resolved. A more recent development has been the acceptance by the African National Congress, the ruling party of South Africa, that it is time for dramatic action, and more left-wing elements within the party have called for what they refer to as expropriation without compensation. And in fact, that policy was adopted at the National Congress of the ANC 2 years ago. And quite recently, the government has published proposals to amend the constitution to allow for expropriation without compensation in certain circumstances. Time doesn't permit me to go into all the details, but it is ultimately quite limited in impact. It's not going to hit residential property. It's only going to be targeted really on unused farming land. But it does indicate a level of desperation amongst those who haven't been able to get their land claims dealt with in a reasonable period of time. In relation to your last question, what is the state of victims in South Africa today? For many victims who have been unable to benefit in in government programs such as Black Economic Empowerment, which is largely targeted at the Black middle class, their situation is a fairly parlous situation. Indeed, we often call that generation the lost generation. They've lost out on education. They've lost out on the ability to engage in adequate pursuit of livelihood for themselves and their family. And in fact, there is a sense of deep betrayal that the ruling party has abandoned them. And that's why we still see the need for much lobbying, much reform, as well as litigation. Thank you.
I've been told that we have another question from the floor. Is that accurate?
Good afternoon. First of all, I would like to introduce myself because it's very important to interact with Mrs. Elena. It will be good for her to know who she's interacting with. My name is Hamid Al-Ajili. I'm a former prisoner, political prisoner, and I'm just like other thousands of victims who are trying to find solutions or a program or reparation program. And I represent most of the victims. I would like to express our failure and frustration maybe after 2 years of the end of the proceedings of the Dignity and Truth Commission, and after the final report and its outcomes, we express our frustration because the government did not respond positively, especially the parliamentary committee did not even try to find solutions and to see how so far, after 2 years, the Dignity Fund has not been established, let alone trying to find solutions, because they would like to make us go astray, because the opening of this fund is linked to reconciliation and plundered money, and they would like us to go astray. However, I would like to say that most of the victims, after the report, most of the victims are satisfied or were satisfied with the marks that were granted to them, and they were waiting for the opening of the fund. However, there is no political will whatsoever by the consecutive governments. Maybe we're not really concerned about the government as we are concerned about the parliament and the parliament committee, which will provide support to the victims because they can summon them, they can also invite the representatives of the NGOs dealing with this file. Many groups on NGOs have been neglected, and maybe the pandemic has confined our and limited our movement and as NGOs to stand up and defend our rights, to defend our file. So the question I wish to address to the international organization is the following. How can the international organization help the local Tunisian NGOs? I don't know, maybe they can exert pressure on the state, or they can provide us help to open this reparation fund, or to see how it can be funded, where we can get financial resources, because our solution depends on the opening of this fund, which has not been opened so far, because we really express, I would like, on behalf of all the victims, I would like to express our frustrations. We work with the NGOs, we see people passing away, and I have recording of that. I would like, and you know, some people working with me, like Mr. Mohsen Migri, passed away, and at a time when he was trying to find solutions to this problem. Many victims now are passing away 10 years after the departure of the tyrant, and 10 years after the waiting time and expectations. But so far, the victim in Tunisia sees himself looking to the right, to the left, but feeling lost in the and facing a dumb government which does not want to listen to us. You know, we see like tyrants have their share, and their interests are defended in this country, unlike the interests of the victims. As a matter of fact, they have been said to have received so much money, which is not true. So I would like to call upon the international organizations to see how they can help us. I felt even more frustration when I saw the situation of the victims in South Africa, and how so far they have not been satisfied. And I mean, if this is the situation in South Africa, what can we say about the situation in Tunisia? And apologies if I expressed myself in a very tense way. Thank you.
Yep. You know, please first, no apologies for expressing yourself in that way. I think it's actually very helpful that we focus on some of the emotions here, which is something I was trying to address a little bit in my opening remarks, and just trying to raise the fact that this initial process that we're now that is being undertaken is actually what needs to begin this process of reconciliation that you are raising. And I'm sorry for your suffering and for the pain that you are expressing. I think just as a general matter, I think we should probably maybe defer that question perhaps to the next panel, who I think will be very well prepared to talk about these actual funding questions about the Dignity Fund, and the budgetary concerns that we or you'll be facing, or that are being faced, and how those can be addressed. We are running a little behind time at this point. I guess we're running about a half hour behind. So unless anyone else has a comment in response, Howard or Lena, perhaps we defer to the next panel to take up this very broad question.
No further comments from my side, Elena.
So then I just would like to thank everyone for your attention, and thank Howard Varney and Lena Sarmiento for participating. I think wait, I'm getting another message here. I think there is one additional question, so let me just defer and see. I assume that's coming from the floor. Yes.
My greetings to all participants, to the speakers. My name is Bashir Khalfi. I'm a former political prisoner. I spent 15 years in prison, and I was sentenced for 50 years in prison. Unfortunately, I'd like to add to what my colleagues have said, that unfortunately, after the Truth and Dignity Commission has completed its proceedings and submitted its final report with the decisions regarding reparation for the benefit of the victims of the dictatorship, we only notice that the successive governments, unfortunately, failed to pay any attention to the victims. The victims are now passing away. Every week, a caravan of victims is passing away. And what is really unfortunate that today we notice that the Speaker of the Parliament today is raising the issue of reconciliation, and he appoints one of the advisors and consultants with the secretary of the former political party that was ruling the country under the dictatorship of Ben Ali. Unfortunately, the victims have nothing, no one to support them, except some of the components of the civil society that is devoid of any support. The big the big organizations like the trade union in Tunisia and other organizations are not considering the issue of transitional justice as a priority, and based on the different presentations and based on what we are suffering in Tunisia, I kind of sense that the process of transitional justice is not going to address the thousands of the victims, that transitional justice is not an effective mechanism as we expected it to be, and that is likely to provide the appropriate reparations for the victims. Unfortunately, I was shocked when I heard about the case of reparation in South Africa, about $5,000, that amounted to $5,000. Everybody realizes that South Africa is not a very rich country, but the victims in South Africa were not paid due attention, let alone Tunisia, which is, unlike South Africa, is a poor country. And a reparation in Tunisia is minimal, especially the state's commitment, which is 10 million dinars. That doesn't amount to the smallest margin of the Tunisian national budget. Unfortunately, all the state institutions, especially the government, is not paying any attention to the process of transitional justice. As Sister Hamida has previously mentioned, how are we going to be able to reach out to our rights in peaceful fashion and with the least amount of violence? Because unfortunately, the victims, on the 10th of December, we have the International Universal Day for the Universal Human Rights Declaration, and we expect a lot of violence to be perpetrated by the Tunisian law enforcement system. So how can we, as victims, obtain our rights without having to really be in this face-off in the future with the law enforcement? This is the status of the Tunisian victims in Tunisia. Thank you.
Eleanor, perhaps I'll just say that the last two speakers, in fact, have indicated a justifiable level of frustration with the lack of delivery and the apparent lack of commitment on the part of the Tunisian state to live up to its promises under law, and perhaps Tunisians and others need to advocate around why it is reparations is important. It's not only redressing individual harm and suffering, it's also about promoting national reconciliation. And given that the Speaker of the Assembly has invoked a reconciliation, it would seem to me that the Speaker needs to be reminded that providing adequate and prompt reparations will greatly facilitate the national reconciliation project. And by neglecting reparations, the objective of national reconciliation is seriously undermined and retarded.
Yes, so thank you, Howard. And I think I have a feeling that may have concluded this first session, and then we will be beginning the next session, which will be, as I mentioned, about the Dignity Fund and the budgeting and financing questions, which I think will go a long way in maybe starting this discussion that people have begun right now.
Thank you, Helenia Newton, for her excellent management of the session. Thanks to Howard Varney and to all the speakers. We now move on to the second session that will be about ways of funding reparation programs and the recovery of ill-gotten assets. And this session will be run by Ruben Carenza, the chief expert of ICTJ. I would like to say that the MP Khlifi apologizes for not being able to attend due to the continuous and ongoing proceedings inside the Tunisian parliament. The floor is yours, Mr. Ruben Carenza.
Thank you very much, Haytham. I'm just confirming that all of you can hear me. Haytham? Yes. And also checking if Priya, our other speaker, is also online.
Yes.
Hi, Priya, and hello to our partners and participants both in Tunis as well as those participating remotely this morning in many parts of the world and this afternoon in various parts of Tunisia. It's unfortunate that our other panelist, parliamentarian Bashir Khalifi, is not able to join us. Let me just mention that he is a member of parliament and is a member of the Parliamentary Committee on the Wounded and the Martyrs of the Revolution, as well as the Transitional Justice Committee in Parliament. And I was interested in asking him not only about the work of Parliament in Tunisia in relation to implementing reparations, but more specifically, how Parliament and other parliamentarians are thinking about funding for reparations. In other words, have they thought about how to raise money to fund both the operation of the Dignity Fund, which, as other panelists have mentioned, is the name of the institution that is meant to implement reparations in Tunisia, as well as the actual funding for the various reparations measures that are expected to be implemented in Tunisia. As you can see in your program, the topic of this session is funding for reparations programs. And in the title of the topic, I have included some of the different ways that reparations have been funded in different countries and which are examples of what Tunisia might be able to do, as well as other countries might be able to use. Our panel will also have an economist who has worked on not just the question of international development, but on the responsibility of international financial institutions in the development or lack of development in various global south countries. Her work has focused on how the different prescriptions of international financial institutions, from the World Bank to the International Monetary Fund, and perhaps even regional economic institutions in the Middle East and Africa, in Asia, or in Latin America, have also pursued economic prescriptions that some have described as neoliberal economic policies, how these neoliberal economic policies have led to underdevelopment in the various developing countries that she has worked in, but also from the point of view of transitional justice, how these economic policies have in turn led to social inequality, grievances, human rights abuse, and of course, dictatorships, such as what we have seen, among others, in Tunisia. So I will ask our other panelist, Priya, to talk briefly about her work, as well as to talk specifically about the topic we asked her to discuss. Before she starts, I will mention that one of the most relevant articles I've seen recently about reparations, debt forgiveness, and the responsibility of international financial institutions to contribute to reparations was written by Priya. We will post a link on the Facebook live stream to that, but right now I will ask Priya to begin her presentation. Priya?
Hi, can you hear me, Ruben? To this discussion. It's a real honor to be here and to come and share what I've learned about reparations so far, working as an economist in international development. So I would like to just say a little bit about myself before I get into the material and the thoughts that I wanted to share with you. So I was kind of very much trained in the neoclassical approach to economics. And that teaches us that kind of the market and its trickle-down effects will eventually lead to a development trajectory that will mean that there will be even growth and most will be able to participate in the rewards of growth. I think that when I started to encounter the reparations tradition, which was about 2 years ago, it really challenged a lot of the mainstream economics that I think a lot of the profession is based on. So for me, it started to unravel a lot of the kind of norms and kind of orthodoxy that goes with the economics profession. And I think that's really important because it is those norms and those values that really underpin the way that the macroeconomic framework is set up for countries that are weaker, less powerful, or whose resources are there to be exploited. So that's just a little bit of background about myself. In coming to this discussion, I'm really keen to hear over these 2 days what other speakers have to say, because I'm learning about Tunisia. As Ruben said, I wrote a piece recently on the complicitness of the IMF and the World Bank in paying reparations based on the debt policies since right from neo-colonial eras and continuing today as well. And in that, I did some research on Tunisia in particular. And what really struck me was that there is a very strong case for austerity based on particular policies that have been implemented by the IMF and the World Bank. But I'll come a bit more to that a little bit through my discussion. So, I mean, in the program brief, there was some really interesting points about how the operational challenges can be really hard to overcome in designing reparations programs, raising funds for reparations, and building the capacity to distribute them can be difficult as well. And I really liked the perspective that was there in the background material, that the difficulty isn't because there aren't funds or resources. The difficulty lies in the misconception about the cost of reparations, or that it means only reparations in a traditional monetary sense, which is, definitely, I think, the movement itself is a lot broader than compensation. Compensation is one angle. So my interest has been in the institutions that have imposed austerity measures, and in particular the austerity measures imposed by the World Bank and the IMF. And I think that that's worsened poverty and unemployment, particularly for those in marginalized regions, particularly those who have been victims of dictatorship periods and where there's been human rights violations, and particularly in those areas of the world which overlap, which were colonial subjects as well. So this brings me to kind of the arguments that I am trying to make in the spaces that I'm working in, which is that there is a case for debt repudiation. So I know the title of my talk was about debt forgiveness and kind of debt cancellation, and that is very much kind of the kind of advocacy and messaging of the INGO sector. But I'd actually go further than that, and I'd actually say that we as a community of activists working across the world in different reparations contexts should actually be questioning the legality of the debts owed by countries who have been depleted of their resources and had their economic autonomy taken away. And I think that the truth and reparative justice process is part of this reparations tradition. So for what I've learned from it so far is that, it's very much a Pan-African derived momentum for global solidarity, for liberation and the realization of rights of the oppressed all across the world. And within that, decolonization is one approach as well. And I think that that's really important because it then enables us to go further than the actual case for reparations. It allows us to say there's something about the economic apparatus and the values behind that that's not working if we're in this model where we are asking for debt forgiveness, because that's not, the vested interests, the most powerful, the most elite have no interest in writing off so much of that debt. So what we see in, global moments, as we've just seen now with COVID, is debt rescheduling or marginal approaches to debt holidays, but we don't actually see a core argument coming through as it needs to about cancelling the debt altogether. So, I think this goes back to the kind of thing that we're very much told by policymakers and different decision makers that the system is not broken, and the problem is that we are not part of it. For me, reparations is a completely different lens. The system is the problem, and steps towards acknowledging and dismantling it, and in some situations, reshaping the structures of the world are needed. I think that that's really what's drawn me to, that it kind of continues the tradition of political resistance to neocolonialism, as we saw in the 1950s and 1960s, when many African leaders challenged a Western-led approach to development and tried to take control of their own agenda. So my work has led me to really try and engage holistically in the idea of reparations, and there are different forms of that. So one form that I think is really important to mention here is restitution. And I think restitution represents one of the most wide-ranging reparations options. It's amenable to diverse applications. It can serve to facilitate the return of real and personal property for previous individual owners, provide stolen wages and lost profits for labourers, or repatriate tribes and clans to ancestral lands. And I think, just as we just heard from the gentleman before who asked the question, who'd been imprisoned for 15 years, this is, the restitution element is really important in cases of physical imprisonment as well. The other aspects are rehabilitation, satisfaction of and guarantees of non-repetition, and then relinquishment, which goes back to the idea that work is also focused on, which is about assets and their return. And I think that, I think it's really important to take on board all of these 5 different multifaceted areas and aspects of reparation. Because I think when we talk about figures, compensation is not the only remedy. And the nature of some discussions can put it to compensation. It is a big part of the reparations process, but I think there's something for me that is about recognition, and that people exist. People have their own ideas about the kind of changes they want to see and how to bring them about. And I think that's why truth and dignity is so important. And I think that what I've learned from the reparations movements in the UK is that it's about all affected stakeholders, and testimonies have to be heard, therefore, in the UK context, for example, from across Africa and the diaspora, to get a full sense of the harm. But I think that, for me, I would be keen to sort of really hear in the discussions that follow, how do we get a full sense of what the harm has been in the case of Tunisia, and what aspects of public consultation are further needed, and how does this then make the case for kind of the strength of the response as well? Because I think when in the territory you're talking about debt forgiveness, we are asking really for the right to futures for different people, future generations, but also people who have been victims of huge human rights violations. And I think that we want to come at it from a sense of how can harm be taken on board, and how can truth-telling prevail in this process. So in terms of kind of, the work, that some of the things that I've been researching in the case of Tunisia, I've been looking at international financial institutions' culpability, and Tunisia's truth and reconciliation process, I think, really offers a strong case for reparations in relation to IFI culpability. So the Truth and Dignity Commission has published a memorandum to the World Bank and IMF, as well as to France, seeking reparations for Tunisia's victims of human rights violations. And this, it found that following the revolution of 2011, the IMF and World Bank bore a share of responsibility for social unrest linked to historic structural adjustment policies. And the Commission set out a case that both institutions pushed the Tunisian government to freeze wages and recruitment in the civil service, and reduce subsidies on basic consumer goods, which led to social crisis and conflicts. There were 3 aspects of reparation: apology, financial compensation to victims, and cancellation of Tunisia's multilateral debt to these institutions. And what we've seen is the IMF and World Bank have failed to respond to the Commission's call so far. But now, once again, Tunisia has to resort to borrowing from the IMF to respond to the COVID-19 pandemic. So I think, the starting point has to be to challenge the legitimacy of this accrued debt and writing it off with no caveat. Recognizing that, this would threaten macroeconomic stability. I think that when you think about mechanisms for funding this, I think wealth taxes are one of the ways where risk might be, the kind of funds can be raised in a plausible way. But I think Ruben's idea of assets and asset relinquishment, asset return is really, really important in the case of Tunisia as well. And I think the legal emphasis is already there, so I'm really looking forward to hearing more. This is the first time we're exchanging as well in this setting, so it's great to be in your company. would say, overall in reflection, I'll talk a little bit more about debt in Africa in particular, and a bit more about debt repudiation. But I think that the reparations approach has not yet been extended to the international system. And, actually, when we go back to the origins, debt packages were fixed knowing that low-income countries could not...
Unfortunately, the sound quality is really, really bad. That's why it is impossible to translate. We need to improve the internet reception, please.
Priya, are you still there?
Yeah. I just had a problem to the translation was really hard. Shall I continue?
Yes, we have some
Unfortunately,
issues
we
with
cannot
the
hear the
connection.
speaker, please. We need to improve the quality of the sound, otherwise it would be impossible to translate.
Also, maybe you can slow down. That might help in terms of just translating and being able to catch up. So please, go ahead.
There's no problem whatsoever about the speed, but the quality of the sound that is interrupted, constantly interrupted, which makes any understanding impossible. We cannot make out what the speaker is saying because of the continuous interruption of the sound.
Let's try again.
From the origin.
I'm so sorry. Okay.
So,
I'm so sorry.
So what we will do, Priya, in the meantime, is I will give you time to maybe reset the connection. Is that possible? And then I will go ahead and start discussing the related topic of asset recovery. Then we'll go back to you. We have time to do that. So is that something you can do in the meantime? Now we don't have a sound from you.
Do you want me to log back in?
They are trying to fix things here, but the interpreters cannot do the job if they can't hear anything.
So, yes, maybe log back in, and then we will go back to you so you can complete the presentation, and then we can have more questions and answers afterward.
Yeah. So I'm going to just mention, I only have like 3 or 4 minutes left. Like, come back. So
okay.
Just bear that in mind. Okay.
So in the meantime, let me reset. So Priya was discussing the first part of our panel topic, which is debt forgiveness, which Priya characterizes more as debt repudiation as a way of funding reparations programs. This is important in Tunisia, as well as in several other countries for various reasons. One, of course, is the fact that a large part of the budget of the state, whether in Tunisia or in other global south countries, goes into payment of foreign debt. And in Tunisia, a grievance that has been raised and has been raised even prior to the Arab Spring was the fact that access to social services, access to livelihood, access to various human rights that are economic and social rights were limited precisely because a large part of the state budget was devoted to debt payments rather than to these, to the fulfillment of these social and economic rights. So what I'd like to do is stop there for the moment. We will have Priya back once she reconnects, and then I will proceed to my own presentation, and then we will go back to our presentation from Ria. So I don't know if you can see my presentation at this point. Haytham, can you confirm? I'm sharing it now, so I don't know if it's visible or not.
We have the title, the name, your name, Ruben Carenza. We still haven't seen the presentation on the screen.
I used share application.
The technicians are working on it.
How about now?
Yes, it kind of appears and disappears, Ruben. Now we see it. Now we see.
Let me, so let me briefly mention why asset recovery has become important as a source of funding for reparations in Tunisia. The Tunisia Transitional Justice Law is explicit about that. It says that assets recovered through the arbitration process within the Tunisia Truth Commission will help fund the reparations program that is going to be administered by the Dignity Fund. And this is a small part of the law. It does not elaborate how, and certainly it does not tell us how much in assets can be or has been recovered in Tunisia. Now, that's a topic that we can talk about in the course of this session. But let me begin by asking the question that should be asked. Can ill-gotten assets fund reparations program? The picture, of course, might be familiar to some of you. You have the President of the United States many years ago talking in a party with the former First Lady of the Philippines and the widow of the former dictator of the Philippines, Ferdinand Marcos. And I think while this picture was taken decades ago, it shows us how dictatorships and corruption, even under governments that we would normally not characterize as a dictatorship, in the United States, for example, can have implications far into the future. So when you have a dictator's spouse and a would-be dictator hanging out, I think it's important to remember that the legacies of the past can have an impact on how we then deal with it in the future. So to the question, can we fund reparations programs with ill-gotten assets? We certainly can. And again, here, that's Mrs. Marcos and her jewelry, part of which has been recovered and part of which is still in the care of the Philippine government, but are now about to be auctioned to help fund not just reparations in the Philippines, but also an agrarian reform program. I'd also mention that transitional justice has had to deal with corruption and not just human rights abuses, because corruption and economic crimes on one hand and human rights abuses committed by the same dictatorships or warlords or human rights violators are mutually reinforcing. In other words, when dictators and war criminals commit human rights abuses, commit war crimes, they do so in many cases in order to profit from those human rights violations, to profit from those war crimes. But when they profit from those war crimes, when they profit from those human rights violations, they then in turn acquire enough assets, ill-gotten assets, that they think can help protect them if and when they are held accountable in the future. They can use these assets to go into exile. They can use these assets to pay off prosecutors, pay off the police, pay off investigators, or hire lawyers in order to shield them from investigations, to represent them in court, or even to bribe judges, whether domestic or even foreign, so that they will not be held accountable. So in this picture, this is Mrs. Marcos suing me many years ago after in my work as a commissioner in a Philippine commission that had recovered assets from their family. She sued me for the crime of libel. In one interview I had when I was in that commission, I had said, just a few months after we recovered assets from their family, I had said that that decision to return assets to the Philippines, which was affirmed by the Philippine Supreme Court, showed that her husband was a dictator and a thief. For that, she sued me in court. So she swore to her statement, suing me for libel. So immediately, the journalists who had covered what I said, which was the basis for Imelda Marcos' case against me, came back to me and asked whether I had a reaction to her filing of a case against me for libel. So I said I was sorry. I was wrong in calling her husband a thief and a dictator, because I said I should have instead said that her husband is a dead thief and dictator. I mention this because it's important to not only do the technical work of asset recovery, but also do the political work of asset recovery. And part of that is to pursue corruption as part of transitional justice. So as my colleague Howard Bovvarny mentioned earlier, in South Africa, while the Truth and Reconciliation Commission was able to mobilize public attention and carry out truth-seeking with respect to human rights violations, the transitional justice process in South Africa failed to deal with the impact of corruption, as well as to deal with reparations. In 2006, a couple of years after the South Africa Truth Commission report came out, a civil society group in South Africa actually examined whether the failure of the South Africa transitional justice process to pursue corruption during apartheid had consequences for accountability. So this is a quote from that report in 2006. It should have been important to pursue corruption in South Africa because it would have demystified the position that South Africa under apartheid was corruption-free. Instead, the atmosphere of secrecy, oppression, and authoritarianism created a climate in South Africa in which corruption was encouraged. So the lesson here is that corruption, whenever it emerges as a legacy of a dictatorship or of a conflict, should be made part of transitional justice. It will help overcome mutually reinforcing impunity, as I discussed earlier. It can draw a more complete picture about the past, and it can break the myth of the incorruptible dictator. For example, Augusto Pinochet of Chile had propagandized himself as an incorruptible dictator, that even if he was repressive, he was not corrupt. Well, that myth was broken when Chileans found out that Augusto Pinochet had laundered money, sold weapons, and profited from his dictatorship. Another reason why transitional justice should address corruption is that it funds reparations, as I will discuss next. Now, there have been truth commissions that only focused on corruption. In Bangladesh, they had a 2008 Truth and Accountability Commission that only dealt with corruption. In Pakistan, they had a national reconciliation law that was only about corruption. In the Philippines, there was an attempt at creating a truth commission that would focus mainly on corruption. And in Greece, there was a truth commission that was focused on public debt organized by parliament. And I think maybe we can ask Priya about this later. But the problem with these truth commissions that only focus on corruption is that they do not link corruption to the human rights abuses committed by the government of the past. So to answer the question, can asset recovery fund reparations? The answer is not only yes, but you have examples here, 3 of them recent, that I think are helpful to know. In Peru, over 170 million in assets of the former dictator Alberto Fujimori were confiscated and used to fund reparations in Peru. And I stress the word confiscate because the law that the Peruvian parliament passed after Fujimori went into exile was a law on confiscation. They left it to the ex-dictator and his family to prove that their assets were not ill-gotten. In the Gambia, the former dictator Yahya Jammeh, who fled a couple of years ago to a neighboring country, Gambia has organized 2 commissions, a truth commission and a separate commission of inquiry on the assets of ex-dictator Jammeh. And these 2 commissions have begun to work together in terms of their findings, in terms of their investigation. And the government of the Gambia has already begun to recover assets. 1 million of the assets recovered from ex-dictator Jammeh, a large part of this comes from assets in the United States, in the state of Maryland, which was returned by the US government to Gambia. 1 million of those assets will now be used to fund reparations. And of course, in the Philippines, you heard about the Philippines case earlier from the former chairperson of its reparations agency. The reparations program that her agency implemented from 2013 all the way to 2017 was funded by assets recovered from the family of Ferdinand and Imelda Marcos in 2003. The commission of which I was part recovered 680 million in assets of the Marcoses from Switzerland, and a law was drafted by the commission and eventually passed a few years later, setting aside 200 million of this amount of 680 million to fund the reparations program in the Philippines. But it's important when considering asset recovery as funding for reparations to actually have an asset recovery strategy. In Peru, as I said, a law called FEDODAI set out how this process of asset recovery would be done and its connection to funding for reparations. In the Philippines, like I said, the reparations law set aside 200 million and ensured that this amount was protected and separated from the regular state budget so that when reparations would be implemented, the funding would still be available. In fact, in the Philippines, because the 200 million was not spent immediately while waiting for the reparations law to be passed, it continued to earn interest and income. So the law later on provided that $10 million from this income, in other words, income from the 200 million was going to be used for a related reparations initiative, which was for memorialization. A memorialization commission was established in the Philippines, and it's now operating, and 10 million from the assets, from the income of the assets recovered is now being used by that commission. So this is an example of memorialization in the Philippines. While this is funded separately by a foundation linked to victims, this is an example of how memorialization can happen and can be funded through asset recovery. So when I say that asset recovery by the state has to be strategic, it's important to consider why asset recovery is better as a strategy for recovering assets and for funding reparations than other possible strategies. One example of another strategy is litigation in foreign courts. And in the Philippines, as well as in many other countries, victims have gone to foreign courts in the United States, in Europe, in regional human rights courts in Latin America, to seek damages against perpetrators of human rights violations. While those cases can be helpful, and in some cases those cases in foreign courts or in regional human rights courts have led to reparations programs, asset recovery can be more strategic, can be more sustainable because of the very nature of the state's involvement. States can seek mutual legal assistance from other states. That's what's done by the Philippines, that was done by Peru, and it's now being done by Tunisia through the state litigation agency in charge of asset recovery in Tunisia. States can negotiate or litigate, if necessary, against individuals or even other states. One example is the Democratic Republic of Congo has filed a case for reparations against Uganda at the International Court of Justice. States can invoke their human rights obligation to provide reparations. This is important because unlike individual cases filed in a court, this obligation of states to provide reparations is contained in human rights treaties. It's contained in the Convention Against Torture, for example. It's contained in the Convention on Enforced Disappearances, as another example. Now, it's not only states that seek to provide reparations that can invoke human rights obligations. It's also states from whom assets are sought to be recovered that also can invoke human rights obligations on reparations in order to return those assets. This is precisely what the Philippines did in relation to Switzerland. The Philippine government told the Swiss government in the litigation involving Marcos assets in Switzerland that if the assets were returned by Swiss banks to the Philippines, it will help the Philippines fulfill its obligation to provide reparations to victims of the Marcos dictatorship. Another point to remember is that the UN Convention Against Corruption contains a chapter, Chapter 5, which requires states to cooperate in asset recovery. So asset recovery by the state is more strategic and more sustainable. And one comparison is again in the Philippines, where as Lina earlier said in her panel, there was a separate case filed by victims of the Marcos dictatorship in the United States, and as a result of which a court in the United States awarded damages to the victims against the family of Imelda and Ferdinand Marcos. Unfortunately, the same assets that the lawyer, his name is Robert Swift, that the lawyer for the victims of the United States wanted to use to enforce this U.S. judgment were the same assets already recovered by the Philippine government. Moreover, not all the victims in this case in the United States were included in the larger universe of victims in the Philippines who were entitled to reparations. And so when distribution of money that was obtained by SWIFT from other Marcos assets in the United States was done in the Philippines, many victims who were delisted from his list complained during that distribution. And so that was the reason why it's important to have a larger comprehensive reparations program. I'll skip some of the slides so that we can go back to Priya, but I'll quickly focus on the lessons learned in asset recovery and funding reparations. Recently, ICTJ organized a conference on truth, accountability, and asset recovery. This was one of the last activities we did in person in Tunisia. And we had participants from the Gambia, Kenya, Armenia, and of course, Tunisia, as well as a Swiss lawyer, speak about asset recovery and its connection to reparations. So you can see this publication in the ICTJ website. Let me now go quickly to the cost of reparations and whether asset recovery alone is enough. In Chile, one estimate we have is that the cost of reparations in Chile has reached $1.5 billion. So that this is the breakdown of the total cost. Now, Chile is a relatively affluent country, industrialized and able to fund reparations, even if it costs $1.5 billion. But compare it to Sierra Leone, a post-conflict country, one of the poorest in the world. In Sierra Leone, funding for reparations actually came from the Peace Building Fund because the Peace Building Fund had extra money at the end of the fiscal year when reparations started there. The actual money from the Sierra Leone government was only 250,000 contributed by the government to fund salaries and equipment of the reparations agency. So you can compare Chile, capable of funding reparations, and Sierra Leone, incapable of funding reparations on its own. So our assets recovered enough. This is a picture of Ben Ali, the former dictator, visiting Mohamed Bouazizi, the unemployed Tunisian who set himself on fire many years ago and then started the Arab Spring. One question I always ask is whether he is eligible for reparations, given that he set himself on fire to protest the fact that he was prevented from earning a livelihood. And often we focus on violations of human rights that are committed by perpetrators, by the military or by the police, torture, disappearance, sexual violence, killings. But what about human rights violations that constitute economic and social rights violations? Should they be subject to reparations? So in Tunisia, you have seen that social and economic grievances have continued even after the Arab Spring. This is in Kamour, in the Tatouine region of Tunisia, where young people have protested their lack of employment by trying to close down the production of hydrocarbon exploration in that region in order to demand jobs for themselves. So when we talk about transitional justice, fighting corruption, we're not only dealing with corruption itself, we're also dealing with the economic and social policies that lead to corruption, that enable dictatorships, and that lead to grievances that in turn lead to revolution. This is a picture of Tunisian activists from the Manich Masama movement, the movement called I Will Not Forgive, because they protested against amnesties to be given to corrupt businessmen and former officials of the dictatorship in Tunisia. So let me end here and point out that when we deal with both human rights violations and corruption, we are more likely to prevent legacies of dictatorship, legacies of human rights abuse, reinforcing impunity for corruption from happening again. So let me end here, and then we can go back to Ria and her presentation.
Thanks so much, Ruben. I'm going to keep my video off in the hope that the internet is better. But I just want to say that I've learned so much from your presentation, and I think that
indeed, the sound is much better indeed.
Okay, brilliant. Okay, great. So I'll keep the video off for now. But that presentation was really informative, and I think that this is exactly the crux of kind of the reparations challenge of kind of helping stakeholders, especially those that are government stakeholders, to understand that it's not an impossible challenge and that the rationale for debts to be used is there. There's other mechanisms as well. There's debt, as we're discussing in some of the ideas I put forward, and there's taxation angles as well that can be explored. But to think, because I think that in a lot of the spaces that I'm in, it's one of the first challenges that I often get, especially in the INGO space, is that, you know, it's too difficult to kind of conceive how to pay reparations. And I think what you have just brought to this forum, Ruben, is actually it's not a kind of abstract thing. It's happening in so many different contexts, and it needs to happen. This is part of healing. This is part of recognizing trauma and harm caused. And this is about a moral imperative to kind of really look at what historical crimes have been caused and what violence still ensues. Because in many ways, I think that, you know, the kind of neo-colonial approaches have just reproduced different forms and structures and systems around why we have kind of, you know, the kind of vast inequality that we do. So there were only a few more points to add from my perspective. I think I wanted to sort of draw the point that, you know, in the context of UK, for example, that it's really interesting because even when countries have become politically independent, as they have in the context of the UK, a large empire, Britain has extended its new form of imperialism through imposing debt on other crisis-afflicted nations. And those nations have virtually no power to reject such offers. And so I still think that we're in a situation where the reparations approach has not been extended to the international system. And actually, the reality is that debt packages are fixed, knowing that low-income countries may never pay them off. And I think that the morality of having an economic system based on that being well known at negotiation time is a realization that we need to sort of encounter as well. And I think, you know, even like when we see like climate crisis affecting different countries, so whatever kind of forms of oppression it is, human rights, climate change, humanitarian disaster, even amid devastation and crisis, debt is usually rescheduled rather than written off. And I think we saw that as in the case in 2019 with Cyclone Idai in Mozambique, which would have been an ideal scenario in which to have a very real, very important discussion about just writing off the debt that kind of really severely restricted Mozambique at that time. But instead, it's always a financing option. And I think that we then build up more and more vulnerability and more, we're robbing countries of more and more of their economic autonomy as well. And when we think about like actually COVID-19 and what that's meant for the debt model and why reparations are so important, particularly now, I think the pandemic provides a really clear and current example of these consequences of the perpetuation of power. Many countries are struggling to respond to the health and economic consequences of the pandemic, and they have limited resources, as we know, to support health systems, which have been decimated by earlier neoliberal policies. If there was like something along the lines of a new allocation of special drawing rights, if that had been made available, accompanied by a mechanism for their fair redistribution or policies allowing lending quotas to be exceeded, I think that many low-income countries in particular would have had a better chance of tackling the current crisis. So I think, you know, COVID's really brought a moment of realization about why debt repudiation, questioning the legality of this debt is so fundamentally critical. And I think we're back in that stage of kind of asking almost, seeking permission to sort of get policymakers to kind of really be warmed up in a compassionate mode towards the debt that they themselves have imposed. And I feel that that's not going to bring about the structural change that we need really moving ahead. I think I just wanted to end with, a couple of points, both on odious debt and debt in Africa in particular. So I think, the extent of capital flight particularly from sub-Saharan Africa has been written about quite widely. And estimates range from something like 700 billion in the past 4 decades. But whilst most of the foreign debts are public, they are actually owed by the people of Africa through their governments. And there's, lots of intimate links between foreign loans and capital flight. And of the money borrowed by African governments in recent decades, more than half departs in the same year, with a significant portion of it winding up in private accounts at the very banks that provided the loans in the first place. And then meanwhile, you have the situation in country where debt service payments continue to drain scarce resources from Africa, cutting into funds that are needed for public health, that are needed for other social needs. And I think that, particularly in the case of African governments, there's a case for repudiating these odious debts from which people derive no debt benefit, and the international community itself should assist in this effort. And I think that's vital for anyone working, around the kind of economic system and looking at its viability for low and middle income countries. So I wanted to end with just, a little bit of kind of background on the definitions of odious debt and international law. And from my understanding, a nation's debt can be considered odious if three conditions are met. First of all, there's an absence of consent. So the debts were incurred without the consent of the people. And this is typical when the debts were incurred under an undemocratic regime or under a military dictatorship. Secondly, a debt is odious if there's an absence of benefits. So the borrowed funds were not used for public benefit, but instead went for private benefit for perhaps leaders and their associates. And the absence of the benefit condition is evident when loans are used in ways that actually harm people, for example, by financing state repression, but also when loans are used to fund capital flight. And then the third area is around odious debt, is about creditor awareness. The creditors are aware of both of those principles above, the absence of consent and the absence of benefits. And I think that if the creditors are aware of that, that shows, some kind of, as Ruben's been saying earlier, that there's a corruption that's being used through the debt mechanism here that's allowing this perpetuation of the neo-colonial project. So the definition of odious debt, really explicitly rests on how the money was used, not on whether servicing the debt would impose hardship on the people of the country, but just, it's also about its actual usage. And I think that when we think about these types of international law considerations, I think that the kind of argument around debt relief or debt forgiveness becomes quite weak. And we really need to go back to that model of kind of, looking at the structural issues around why these debts were purposely structured in the way that they were. And there was obviously so many power dynamics here that need to be visibilized and need to be then acted on from activism, as Ruben is doing. So I will end there, but thank you so much again for the opportunity to be in this space. And I'm really looking forward to hearing the continuation of the discussion the rest of the afternoon and tomorrow as well. So thank you.
Thank you, Priya. And I think it was a useful return to the first topic, foreign debt, and how it connects to asset recovery. Two things I would add quickly to the two presentations, mine as well as Priya's. You can see from those presentations that funding for reparations, whether from assets that are recovered or whether from the repudiation, cancellation, or simple forgiveness of a country's foreign debt, are in the end dependent on foreign governments, on foreign countries, on foreign institutions. When I say dependent, I mean that they require the involvement of foreign governments, foreign banks, for example, and other creditors. But at the same time, when I say that they require the involvement of foreign institutions, it does not mean that domestic institutions, national government, the government of Tunisia, for example, should not initiate the process, should not pursue the process, should not demand that assets be returned, that debt be forgiven or canceled. So what is important to consider here is that many of the reparations obligations that we need to fund as government officials or as activists who are seeking reparations cannot be met by domestic sources alone. Because if they could be, Tunisia would not be a poor developing country to begin with. Because if we could already fund reparations from state budgets, then there would have been no grievances over the lack of access to healthcare or livelihood or education. There would have been some level of access to economic and social rights that would have prevented revolutions and a transition in the first place. So it's important to remember what Priya said at the beginning of this panel, which was that many of the policies that enabled dictatorship, that led to the grievances against Ben Ali, for example, or even against Ferdinand Marcos or Alberto Fujimori and the armed conflict in Peru, that many of the grievances were fed and enabled by economic and social policies that led to marginalization, that led to poverty, that led to inequality, and in turn led to opposition to a dictator or even armed resistance to a government. Now, these policies cannot be, these economic and social policies cannot be separated from and treated as if they were completely different from the human rights violations committed by dictatorships or by governments in an armed conflict. For so long, transitional justice has sort of separated these events, human rights abuse, corruption, social and economic policy, in the way it addresses reparations or accountability more generally. And I remember one very important article from many years ago written by a friend who teaches law at Harvard. She describes the way transitional justice deals with economic and social policies and their impact on a society as mere background. She says that transitional justice only deals with poverty, with austerity measures, with landlessness and inequality as if they were just in the background, and that at the foreground, in front, are human rights violations, physical integrity violence, that transitional justice focuses on. So it's important for us to remember that economic and social grievances that lead to revolution, that lead to transition, that lead to armed conflict are not mere background. So in Tunisia, the economic policies adopted by the Ben Ali dictatorship, whether it's the liberalization of the economy, the focus on tourism in coastal areas, the opening up of education so that education in Tunisia focuses on the export of labor, for example, that these economic policies led to unemployment, that these economic policies led to marginalization in the southern regions of Tunisia, and that it was this marginalization in the south of Tunisia, in regions like Gafsa, Tatawin, Kasserine, Sidi Bouzid, where a young man who could not find a job, who decided that he would sell fruits instead in front of the town hall of Sidi Bouzid, and who was prevented from selling fruits in front of the town hall in Sidi Bouzid, would end up so desperate, frustrated, and angry that he would then go home, get kerosene, douse himself with kerosene, and then set himself on fire, and eventually die. And then lead to a chain of events, what we now refer to, and in many ways in a misleading way, as the Arab Spring. So this chain of events does not start with Ben Ali and his repression and the self-immolation of Mohamed Bouazizi, which led to the Arab Spring. This chain of events begins even earlier than when Ben Ali decided he would become a dictator. It connects to economic and social policies that Ben Ali adopted after he ousted the first dictatorship in Tunisia, and continued all the way up to the chain of events that led to the Arab Spring. So one of the questions that I would like to ask Priya, and I will add something to whatever she says as her answer, is whether debt forgiveness, to what extent has debt cancellation or debt forgiveness succeeded in the global south? Are there good examples of developing countries that have recovered money, not through asset recovery, but through debt forgiveness? And what has happened to that money that they've gotten back because their foreign debt has been forgiven? Priya?
Hi, Ruben. It's a really good question. I don't feel like I have, you know, the varied answers across the world to answer it comprehensively. But I think that my observations and frustrations really come from the nature of those discussions when the opportunity for debt forgiveness or debt cancellation come up. Because, you know, first of all, you know, there's a kind of macroeconomic stability point, and creditors want to see their loans recovered. You know, that is the law of supply and demand, and there's very little opportunity to really kind of probe moral arguments in that space when we're talking about portfolios that are, you know, to the value of millions of pounds, and that in itself is a business. It's, you know, the kind of business of you know, helping different countries in crisis moments. It's a business in itself to provide a vehicle for stabilization of a country. It's not being done from a moral basis. It's being done because it makes economic sense for those creditors, and actually it's highly lucrative. So when we get into that model of talking about debt forgiveness and debt cancellation, I think that one of the things that draws me, what frustrates me, is that it happens on a very marginal basis. So there may be a certain portion of debt cancellation, or as we've seen with COVID-19, we've actually seen, you know, kind of pauses, debt holidays for 6 months. And I think that in itself, again, what does that mean then for the country? It just means that it's storing up even more harder mountains to climb down the line. And it's, you know, it's the kind of predominating forces of kind of how much capitalism underpins the framework really of the modern economic system. Now, I think that when we enter into the discussion from looking at the legality of the debts themselves, that's when you see kind of, you know, the institutions themselves, I think, more in uncomfortable territory, like really justifying why would they have really envisaged, you know, deciding on a debt, deciding on a kind of IMF country level assessment, then leads to a package of financial rescue that in itself doesn't make sense. It is not repayable in any practical way, but it's still, you know, we still see these policies being rolled out. So I think that I'm still in a kind of, you know, hope that, you know, we can develop the momentum to really lobby harder on this idea of kind of the morality of how the debts themselves are arranged. And I don't think that, you know, we're in a proper kind of discussion space when we're still talking about a forgiveness moral imperative, because I think that, you know, it still implies powerful, powerless, economic autonomy robbed of economic freedom. And, you know, when you still have those distinct dichotomies and you don't see like stakeholders working together in a much more cohesive way, which would be, you know, that is the reparations tradition, to really re-envision a future that works for all, that is kind of about healing, and it's about moving together in a way that's kind of much less about kind of maintaining huge and kind of unequal profits for elites and the most powerful, but moving together in a way that kind of actually creates economic systems that work for all. If we get into that space, then I think that we'd have a much different discussion about debt in itself. This is a high-level answer.
Well, thanks for that. And I agree with you that on one hand, I think it's difficult for international financial institutions like the IMF and the World Bank to take this moral position that debt should be canceled or forgiven. And so they take this halfway step of canceling debt or canceling payments of debt for a shorter period of time, which, as you said, is happening because of the pandemic, for example, and then not deal with the larger question of the unpayability of the debt to begin with. Now, I'll make 2 points that I think might be helpful in imagining how countries like Tunisia and others can use the situation of being a foreign debtor to perhaps raise funding for reparations from debt forgiveness or debt repudiation. One is a more conventional example that we learned from ICTJ work. One of the first countries I worked in for ICTJ was Ghana many years ago. And Ghana at that time was classified by the IMF as a heavily indebted poor country, or HIPC. So Ghana created a National Reconciliation Commission, a Truth Commission, to look at the legacy of its former head of state and dictator, basically, Jerry Rawlings, who staged a coup in Ghana, ruled for several years, and then stepped down from power, in fact, after elections. But Ghana created a Truth Commission to examine the legacy of his government. And as a footnote, by the way, Jerry Rawlings died this week. So I don't know what that means for Ghana, but certainly it's worth revisiting the transitional justice process in Ghana. So the National Reconciliation Commission of Ghana recommended that reparations be paid to a group of victims who came forward to that commission. And ICTJ worked with the government of Ghana to design the reparations process. They did have some money to pay compensation, but it wasn't enough money, and more victims came forward than Ghana had money to pay compensation. But Ghana was able to raise an additional sum of money from a source that at that point was unexpected. I saw in the state budget of Ghana that they had applied for debt forgiveness as a heavily indebted poor country within the category of the International Monetary Fund. And that part of the debt that falls within that program was forgiven. Now, the IMF did not say, we will cancel this debt or this part of your debt so that you can pay reparations. It was, in fact, the government of Ghana, following the recommendations of its Truth Commission, that decided to use the money that was freed up by debt cancellation to fund the reparations program. So that's an example of how, even without any policy or even transitional justice connection, the World Bank or the IMF decides that debt can be canceled, that it can then fund reparations. But there is another way, another examples of where the IMF and the World Bank have in fact directly funded reparations. In doing so, they have not acknowledged responsibility for human rights violations or their complicity in the kinds of grievances that lead to transition, but they nevertheless have helped fund reparations. So 2 examples. One is Nepal, where the World Bank provided around $12 million for Nepal's interim relief program, which was a semi-reparations program for victims of the armed conflict there. The World Bank did not say we are doing this because we acknowledge the World Bank's role in poverty and inequality in Nepal. They just decided to fund, and there's no clear rationale for why they were doing so. In large part, I think it was pressure from neighboring countries that were affected by the conflict in Nepal that the World Bank used to justify funding for reparations there. But there is a more explicit example of the World Bank funding reparations because it's concerned with armed conflict, with the fragility of a country, with the fact that a country cannot move forward without addressing this legacy of the past. And that example is Colombia, where the World Bank has provided some funding for the collective reparations program that has been implemented in Colombia. So you have 2 examples here, one of debt cancellation in Ghana that led to funding for reparations, and the other of the World Bank itself funding reparations in 2 countries. But Tunisia's case is slightly different if we consider what the Truth Commission of Tunisia said, and which Priya mentions in her article that was posted on the live stream, which is that the IVD, the Tunisia Truth and Dignity Commission, in fact sent a memo to the World Bank asking the World Bank not only to apologize for its complicity and enabling of the Ben Ali dictatorship through economic and social policies that led to marginalization, but that the World Bank should help fund the reparations program of Tunisia. So far, I haven't seen any Tunisian government official come forward and say, let's follow this up. Let's see what happens. There's a World Bank office in Tunis. In fact, ICTJ has met with some of the officials of the World Bank in Tunisia, but this goes higher than the Tunis office. So it will be interesting to see whether there are government officials and even activists, or even some of the victims group leaders who are there in Tunis right now listening to us, whether they will in fact mobilize and ask the government of Tunisia to follow up on this Truth Commission recommendation, because many of the victims groups, for example, have, and we heard them earlier, have expressed disappointment in government's failure to act on reparations, on the government's failure to act on the recommendations of the Truth Commission. Beyond complaining and beyond asking government to implement reparations already, I think there's more that can be done by victims groups leaders. There's more that can be done to connect demands for individual compensation with demands for repairing marginalized regions and with demands to change economic policy imposed by international financial institutions. And one of these, of course, is to follow up on the Truth Commission recommendation of Tunisia. So before we go further, I'm going to ask Haytham whether there are questions from the floor or on the live stream.
Now we wish to take some questions from the participants about the topic, namely the funding with regard, for example, as I said, the recovery of plundered money or ill-gotten money. So if you have any question, please do take the floor.
Thank you. Thank you very much. As one of the victims of the former regime, the regime of dictatorship and corruption, before I come to this meeting, despite my interest in transitional justice and my belief in the principles as a whole that govern transitional justice, and as a militant who believes in the universal principles of human rights that we have acquired and that helped us develop our ideas and convictions, I was a kind of upbeat and optimistic that the fate of transitional justice would be a good one, a successful fate. But after listening to all the data on the status and the process of transitional justice in South Africa, in the Philippines, in Chile, and in many other African countries, we note that there are lots of shortcomings and that there was some kind of a legend or an illusion that led us to believe that there were good proportions of success to establish societies in South Africa, in Philippines, where the victims would obtain justice far away from the former systems of hatred and resentment and division in society. But it seems that the inadequacy of the laws and the effective balances of powers, the social and political balances of powers, under the systems of dictatorship and corruption, these balances of power continued to be defective, even after the revolutions and uprisings that took place in these countries where there was corruption and dictatorship. There were imbalances at the level of the provisional constitutions and the laws that governed transitional justice. The question, why why didn't we offset these drawbacks and shortcomings? We know that in Tunisia we have the issue with the recovery of ill-gotten assets. There are laws and there are deadlines that are imposed on the Tunisian state, so that in order to really apply in legal ways. But the successive governments did not comply with these deadlines. And now there's a possibility for these deadlines to expire, and therefore the resources with which we would provide material reparation and financial reparation would disappear. And these resources are doomed to disappearance in the absence of any political will and in the presence of these imbalanced powers. The question at the international level, and our friends in international NGOs that are advocating the process of transitional justice, based on your experience, what can be done in order to face this process? Because the failure of the process of transitional justice will only enhance the previous aspects of division and would even fuel the speech of hate that we would like to overcome. But it seems there is no political will on the ruling political at the level of the parliament and the presidency, and therefore things are not going the right way. We also note that these international NGOs and these international centers, there's some kind of polarization, but in view of human rights principles and in terms of the principles of transitional justice, human rights would entail impartiality, neutrality, and would entail a mentality, a unifying mentality that would bring all the classes, regardless of their political partisanship, in order to create a democratic and a coherent and cohesive society that would reject violence and that would reject social, economic, political marginalization and all these aspects of hatred. But it seems we do not have these factors. There's no unity. With regard to the victims, there's no unity among the victims because there's not enough coaching, there is not enough support for the victims. I notice as a victim the difficulty that we experience in obtaining information, and we are struggling, in fact, to gain access to information. As we really get older, the majority of the victims are exhausted and are really financially, economically, and socially and professionally very strained. There's illness, their aging status. In return, there is not enough coaching, not enough support, and therefore there are no attempts to unify these victims. I notice on some web pages of the transitional justice there are discrepancies among the different movements. We have to have some kind of reconciliation among the victims themselves, reconciliation among the political parties. At least that we can sit down and to avoid that things depend on the balances of power, that things become regulated by the constitution, by the laws that govern reconciliation, that should be also governed by the principles and the culture in order to turn the page of the past. But it seems that this atmosphere is lagging behind in Tunisia, and even the experiences in South Africa. We've heard about the experience in Philippines so far. The victims are still waiting to obtain their rights. In Tunisia, we are just heading towards the same situation. Hence the question here, what should be done? The international experts that we are listening to now, how do they perceive such situation? What would be their advice? How do they advise the lawyers, the judges, those activists in civil society? We know there are lots of divisions and polarization amongst us, and we have no harmony, and that weakens the status of the victims. And the victims, as previously mentioned, the victim is at the core, but we want everyone to be servicing, to be working in the service of the victims. I personally, I have not sensed that really that concern for the victims. I really commend the efforts exerted, however limited, but we call upon our friends abroad or in Tunisia. We want more coaching. We want more support in order to be able to turn the page of the past and to ensure that we exhibit a high degree of self-denial in order to be able to move forward and to root out the foundation of violence that is likely to continue if we do not manage to resolve the issues of the victims, because the aspects of political division, economic marginalization, and the impoverishment of regions, we have been under decades of impoverishment, of marginalization, and we have endured torture, enforced disappearance, imprisonment, arbitrary imprisonments, and arbitrary administrative control. We now feel a lot of frustration, and many victims feel frustration and marginalization. They feel they are real victims. After all of these plights, why do we come to this failure? Why don't we overcome this situation? What needs to be done in the future so that we can overcome these shortcomings? If debt forgiveness is a solution on part of the IMF, the World Bank, what would be the role of these institutions to cancel the debts or to reschedule them? It looks like there is some kind of deceit and misleading that would be bought by some nice people driven by good faith. But there are many people who are caught in between, but in the end the victims will remain as victims in the end, as was the case in South Africa, as was the case in the Philippines, in Chile, and 20 years on we will not be able to survive in 20 years, and those who pass away will go to oblivion. But anyone who passes away would go away. And that is really a failure. We as human beings, we are not right-leaning or left-leaning activists. We have to pinpoint and give due attention to our humanitarian value. We want the specialized chambers, the alleged defendants and perpetrators are not attending, and they are defying everyone because there is no way to compel them to attend. We have no capacity to compel the alleged perpetrators to appear before the courts pursuant to international conventions from the United Nations and from the domestic laws.
Now getting too broad.
We have to have the ability to compel those people by virtue of the law. Otherwise, the situation would really spiral out of control and we would end up in violence. We want to avoid that situation. Now the revolution and the so-called Arab Spring should achieve those gains by unifying people to ensure that all people are respected, that everyone enjoys dignity in full equality before the law. Thank you, and I do apologize for my lengthy intervention.
So let me quickly give a few responses. Let me quickly give a few responses. I'll ask Priya also to comment on the questions around how do we mobilize so that we can achieve some level of debt cancellation or debt forgiveness. But the two things that to me are more practical that were raised by the gentleman. First, many victims of the dictatorship of Ben Ali are getting older, getting sicker, but nothing has happened as far as reparations is concerned, except perhaps some of the urgent reparations measures that the Truth Commission implemented during its existence. And I think this question is even more important for victims who were victims of violations during the Bourguiba period, because they would be much older, or at least many of them would be much older. And in fact, when I went to Tatooine for, I think, the third time last year, I met some of them, veterans of the war against French colonialism, survivors of the massacre in Mount Agri, and the widows and surviving fighters were very old and continued to ask not just for reparations in a material way, but for the acknowledgement that they deserve for their resistance to colonialism and the suffering that they had to endure because of that. So this question of how long do we wait and what will happen for those who are now too old to be waiting is a practical question. And some countries have responded to this through urgent reparations programs. And urgent reparations programs need not be compensation payments. Some of them can be access to social services. And these social services can be tailored specifically for those who are sick, for those who are disabled, and for those who are unable to support themselves because of their age or sickness. And this is in the Transitional Justice Law of Tunisia, which the Truth Commission tried to implement through its urgent reparations program. But like reparations now, that program was also limited by lack of funding. And yet, if you recall, the Truth Commission, in fact, was able to obtain some funding from Parliament to implement that program. Some people, in fact, received urgent reparations from the Truth Commission. We will not go into the fairness of it or the amount involved or the suitability of the benefits, but it's important to note that the Truth Commission was able to obtain funding from the government of Tunisia to implement urgent reparations. What does that tell us? It tells us that the government of Tunisia can actually fund reparations. It might be limited, it might be small, it might not be enough, but it is a start. So it's not completely true that there is absolutely no political will to implement reparations. In fact, it was only during the Essebsi government when the Tunisian presidency, in fact, ignored reparations and instead prioritized perpetrators of corruption by proposing to grant them amnesty. So that's a separate discussion. But it's important to distinguish among governments and leaders in Tunisia. So one question that can answer the practical question of how long must victims wait is whether your current president, Kais Saied, understands your predicament and whether there is something you can do to make him understand your predicament. It was also Kais Saied who, before he became a politician, before he ran for election, before he became president, he once said that assets recovered from perpetrators of corruption during the dictatorship should be used to fund development in the marginalized regions of Tunisia. He even went there when he became president and promised to implement reparations. What has happened to that promise? What has happened to that position? Are victims willing to insist that Kais Saied respond to these questions? So it's important for victims not just to be here in an ICTJ event, but to meet with their parliamentarians, meet with those who represent them in political parties, for instance, whether it's secular, Islamist, or the variations of political parties in Tunisia, and demand that those politicians answer those questions. So that's the answer to the question of political will. In answer to the question about asset recovery and how slow it is, part of the answer is that the changes in government have made it slow. This wasn't a priority for ICTJ. As I said, ICTJ wanted to give back the assets of perpetrators of corruption. He wanted to give them amnesty. And it does not help that the Truth Commission in its arbitration process has not been transparent and clear about what amount of assets were proposed to be returned by family members of Ben Ali, by those who were involved in the arbitration process on the side of the perpetrators of corruption. There's no clarity around that. There's no clear record of how much is involved because victims can ask for that information. Victims can, in fact, go to the presidency, ask the president to open the records of the Truth and Dignity Commission's arbitration process and disclose how much perpetrators of corruption who came to that arbitration committee offered to return. Because if you know the amount of money, if you know how much they were willing to return, then you can determine whether, in fact, that money can now be used to fund urgent reparations for those who are sick, for those who are growing old, for those who are disabled. So that is an answer in part to the problem of asset recovery. But there is a more strategic and long-term answer to asset recovery. ICTJ has been helping the State Litigation Agency in its work to recover assets abroad. Recently, Switzerland and the rest of the European Union has threatened to unfreeze the money linked to Ben Ali and his family members in Switzerland and in the European Union. And if they are unfrozen, that means Ben Ali and his family members can actually get that money out and transfer them. So that freeze is still being maintained. But that freeze will not stay for long unless the Tunisian government proceeds with the trials of the corruption cases involving Ben Ali or is able to produce substantive proof that these assets are ill-gotten even without the trial. This other option of producing proof that these assets are ill-gotten can be done even without a criminal conviction. In other words, specialized chambers do not have to convict Ben Ali, especially because he is dead and cannot be convicted of a crime of corruption in order for Switzerland and the European Union to maintain this freeze. This freeze can be maintained even with a decision of a civil court that says these assets came from corruption. And yet, I have not seen victims' organizations, I have not seen anti-corruption groups, such as iWatch in Tunisia, for example, file any kind of case to obtain a civil judgment in Tunisia that says these assets were obtained through corruption. And what possible evidence can be presented in a civil case that shows these assets were obtained from corruption? The proceedings of the arbitration committee. which, like I said, have not been disclosed to victims, have been left hidden, and we don't know what perpetrators of corruption, family members of Ben Ali, said before that arbitration committee. So I agree with the question about how victims are caught in a trap, but there is one way to get out of this trap, and it is to actually step out and sue the Tunisian state to get these records out, and then use these records to unfreeze those assets in Switzerland and perhaps have them returned sooner rather than later. Priya, you want to address the question about foreign debt and cancellation?
Well, I'm going to take the aspect of what the gentleman said about the lack of victim-centered approaches in these discussions, and how that gets lost when we're in the kind of policy space and we're talking about this. And I think that really, really strikes home to me about kind of, you know, why it's so important that the ethos of what we do is really consultative, is really driven by victims themselves, and that it's wide and broad ranging, like that consultation aspect. I think even the funds for the consultation in itself, that is part of the process. So that has to be really fundamental for me. And I think that, you know, when I really liked what was said in the question about kind of, you know, is there some kind of, you know, is there some kind of corruption going on in these discussions between kind of parties, and how the kind of, especially when you get into the debt discussion, what is going on? And I think that I would say, well, this is the maintenance of the capitalist framework. You know, there is there's networked spaces here of maintaining the eliteness, maintaining the concentrated power. And when we bring the reparations framework into this process, yes, as Ruben says, you know, actually in some circumstances, it is advantageous for the World Bank to pay reparations because it's part of a treaty of peace, and it's needed to establish, you know, stability in which to then move forward into sort of more stable economic conditions. But that's not the ethos behind reparations. What we want is a reparations approach that's rooted in victim experiences, and it's not just about you know, victims and their experience, but their direct descendants, all those that go on and feel the legacy of that trauma as well. And as we know, in the context of so many African colonies, that trauma is still being experienced by so many generations, as we see in the case of the UK and the US. So what I would say in terms of like, what do we do when we get to the space of decision makers and politicians? I think this is about trying to really merge our movements and try and make reparations very much integrated into the mainstream political debates. Now, we've seen like much success. It might be small still, but, you know, I'm really proud of the success that we can see happening in various places. For example, in the UK, we have the Green Party that's committed to reparations, and it's become part of their framework. They're not in power, but they've said that this is, you know, part of what their manifesto would be, an approach to reparations. And that's, you know, that's a big statement. That's a big move forward in the UK context. In the US, reparations has been a point of discussion and vibrant debate amongst Democratic candidates. And we see, you know, politicians like Cory Booker and so many others, you know, talking about reparations, and we have the HR 40 process. So I think, you know, there's much to learn. And then even in the context of kind of, you know, where are these movements and you know, their visibility, I think that I'm continually inspired by the UK movements, the institutions themselves that the UK movement has, which is PARCO, INASA, just to name a couple. And this year and every year on the 1st of August, we have a reparations annual march, an Emancipation Day march. And even in a time of COVID, this year, the march was vibrantly attended with so many different participants from different social justice movements. So I think that this is key for me, that, you know, the reparations movement is part of the climate justice movement. It's also part of the, criminal acts against Black communities. It's part of the prison industrial complex activist movement. These aren't separated out. These are all human rights violations against the same types of communities. And I think that, to keep that victim-centered approach is critical, but also to form forces with different aligned interests and just widen out the kind of political mandate and insert into kind of political processes and that I think that's the way forward. They would probably be the three things that I would say moving ahead.
Hey, Tim, any other questions from the floor?
Mr. Elmi, you have the floor, sir. Mr. Carranza, Mr. Howard, and dear all experts, I would like to hail you. Good morning and good afternoon. Have a good day, have a good night. And this is a multi-dimensional seminar. First of all, I would like to highly commend whatever was said by the other victims who took the floor before me. My name is Almi Khadri. I am the president and the chairman of Al Karama, the voice of the victims, and the founder and member of the Dignity Association, and a member of the Transitional Justice Committee. This seminar in itself will spare you asking questions about the political will. It was the Prime Minister was invited and he did not attend, and a member of the Transitional Justice Committee was invited, wasn't come, and Mr. Abdulrazak Al-Kilani was with us this morning, but unfortunately he left. I hope at least they are following us remotely, or at least they entrust someone to follow the proceedings of this conference and give them a summary of its proceedings. This shows the lack of political will and their absence today. The aim today is to make recommendations. So we were hoping that it would be attended by the Prime Minister or at least his representative. But whoever is going to represent him is not present, and this shows you the degree of political will. Today we heard about the report published by the Dignity and Truth Commission. But the train of transitional justice has come to an end and has stopped. The Prime Minister is a member of the previous government, so he should have implemented the continuity of the state decisions. So 2 months have elapsed since the government took power, and we don't know which path we're going to follow. The victims don't know who to turn to. Even Mr. Abdulrazak Al-Kilani is not really entrusted with the file of transitional justice. He is entrusted with a High Commission which deals with the revolution's victims and the wounded and the victims of terrorist attack. And this is a committee alien to the file of transitional justice. We have to understand the framework of this government. We actually contacted Mr. Hisham Mashishi along with the Alliance to Defend Human Rights, and this is a group of NGOs and groups and international gatherings and groups. So we asked for a meeting, and we explained the goal of the meeting. The goal was very simple. This consisted in integrating the file this is the file of Transitional Justice in his working program, and we were hoping they would keep Mr. Aisha Hamami and the Ministry of Human Rights, but unfortunately our request was not accepted. And then Mr. Hisham Mshishi was appointed Prime Minister, and he presented his program to the Parliament, and we did not see not even a single word concerning transitional justice in his own program and the program of his government. And of course, he deleted the Ministry of Human Rights, and this is quite meaningful. So this government, despite some contacts that we made, he promised 2 months ago the least thing he can give us, you know, we have many questions that are raised, many queries in international seminars and conferences. We would like to have an authority whom we can contact and whom we can ask for, from whom we can ask for advice concerning the reparations program and how it can be obtained. This is missing so far. Without much ado, we'd like to talk about how reparations can be done, and this will undoubtedly give us another picture on the absence of the political state will. We have cases, you know, we have a lot of money plundered by foreign countries. We have also other cases in specialized criminal chambers, but unfortunately, the state representative, who is the person entrusted with the state disputes, has not attended any court case except one hearing or 2 hearing sessions, and we have so many cases from about Tunisia, about the cement of Carthage, also court cases concerning other files, and this is a tangible and ostensible proof about the absence of the political will. With regard to ill-gotten money, I here think that the former government should assume the responsibility because they have not done whatever was necessary to recover these assets. With regard to the victims, the current government is unable to open an account for the dignity fund amounting to 10 million dinars. What do we mean by 10 million dinars? There is only computation, only one bank account of the former president wife, Leila Ben Ali. We are too much tolerant. We still say the former first lady and the former president. We are avoiding using the term dictator, and we used to say alleged to have perpetrated the violations against human rights. You know, we were hoping for forgiveness, official forgiveness, and then we can talk about reconciliation. So 10 million dinar, one account of the accounts detained by Leila Ben Ali is about 80 million dinars. So 10 million is about 10%, 12% of the amount deposited in this account. So the budget has been increased by 30 million dinars. I'm talking here about the Prime Ministry. Since our brothers in South Africa, in Chile, in the Philippines are asking for help from the churches, maybe we are going to ourselves to resort to help from the mosques in Tunisia, and this is the best picture to depict the situation of the victims. In addition to the media attack against the victims who think that they have been compensated too much, as Mr. Karanza has said. With regard to some files, we have contacted the late Mohsen al-Nigri. We were military people, because I was a former military person. We had a meeting with the first consultant and advisor, military advisor, to the President of the Republic. And our files were well documented with all the necessary evidence and proof. And the advisor and consultant really was surprised how come that those files were not opened until that moment. And then we were asked the question at that time, you are said to have received reparations, and this is an official administration thinking this and claiming that you have received some reparations. Even, I mean, the closest people to us will not believe that when we tell them that we do not receive, we have not received reparations, which a word I hate, and that we are begging for it. The specialized criminal chambers, as my brethren have said before, and Mr. Hamdan said, we've been waiting for 2 years and a half. You know, the files have reached the final stage, and none of them has been examined, and no truth whatsoever has been unveiled to us. We don't even know where they have been buried, where the victims have been buried, and where the cemeteries are located. And therefore, today, we need to be determined in order to compel people. They don't observe the law, and therefore, we have always observed the law, and therefore we need to compel them to have this political will. The political will exists when it comes to reconciliation with. We have witnessed this during the various successive governments. Some solutions have been found with the corrupt people in some hidden corners, hidden houses, and so far we don't know who even benefited from this and how much he paid back to the government. We know that corruption is still prevailing, and the best proof to that is was actually dismissed because of conflict of interests. And so the process of reconciliation with the corrupt continues. There was a law, the law in return for compensation, and we refuse all type of reconciliation outside the framework of transitional justice. This is our goal. And reparations, tomorrow hopefully we'll examine this into further detail, is part and parcel of all other processes. We are determined to finalize this process and the work of the specialized criminal chambers. And we, in our capacity of NGO, we sent him more than 300 mails, individual, about official that they ask for. But I don't think that our mails will be answered. With regard to your questions about the law of reconciliation, it's a draft law presented by the President of the Republic, and today, in order to implement his own theory, the reparation for the marginalized regions and areas. But I'm wondering whether this part and parcel of the transitional justice, we have not actually set its pillars and its cornerstones. And all this, there is also another reconciliation called upon by the Speaker of the Parliament, and since he reconciled himself with Mr. Bejkai, since he was calling for total comprehensive reconciliation, have we actually prevented recurrence of these mistakes? The only thing that we gained from the revolution is the freedom of speech, but unfortunately this plague, this pandemic, may God protect you from it, to muzzle us once again and to muffle us once again. Thank you very much, Mr. Ajmi. Anybody else wishing to take the floor to ask a question and to make a query or to make a comment?
So I give the floor back to Ruben to conclude this session, and after which we conclude this day, of course.
Well, I'm glad that we heard not just comments, but I think very important insights into the problem of political will among Tunisian government leaders. This is not a unique problem for Tunisia. In many other countries, it did take a while for reparations to be implemented. And even when they were implemented, it took a while for reparations to be implemented to more victims. Of course, you have to factor in impatience. You have to factor in the situation of victims, getting old, getting sick, disabled. But it's always been difficult, even if on paper it looks like reparations can be done in a systematic way, funding can be found, and that funding can be applied. I think it's also important in a larger transitional justice discussion to remember that when truth commissions are created, or even when specialized chambers are established, it's easy to establish them. It's not easy for them to operate. It took a long time before the Truth Commission actually started its work. It even had to ask extensions in Tunisia so it could complete its hearings and then submit its report. And even when it submitted its report, it had to keep changing that report. And so it took a while. Specialized chambers, it was created in a relatively quick way, but now it's stuck and it's not moving. And reparations is even more difficult because unlike a court or a truth commission, reparations isn't just about one agency. It's not just about the dignity fund. It involves the whole state, whether it's to recover assets or to seek the cancellation of debt or to design and implement a reparations program. You're not only relying on one agency or on one official. You're relying on the political will of an entire leadership and the bureaucracy that has to follow them. And in a pandemic, it's even more difficult to pursue the conventional way of getting reparations implemented. But as people say, in every crisis, there is opportunity. And the opportunity that this pandemic, in a way, gives us is that it lays bare the situation of inequality, marginalization, and economic and social grievances that having a truth commission or having a specialized chambers has not completely addressed. And reparations is one way to address that. So I'm glad that we had this discussion, and I hope that tomorrow, when we discuss actual implementation so far of reparations and then marginalization and collective reparations in the second session, that we can focus on practical questions and answers. And in the final session tomorrow, which I am also very much looking forward to, I think it was important for ICTJ to bring up this discussion by looking again at economic and social policies and how transformative reparations can be. And so we have that discussion, as well as the granddaughter of Salah Ben Yusuf, who also is based in New York, like ICTJ's headquarters. But she will talk about both the personal and family-related issues around the assassination of her grandfather and the lack of reparations and justice for that, but also the larger question of where is the Ben Yusuf family in all of these demands for dignity and equality for Tunisians. So I'm looking forward to that, and thank you again for listening to this panel.
Thank you very much, Ruben. Thank you for your valuable contribution. Our thanks go out to those who attended. We are waiting for you to show up tomorrow to speak about the challenges pertaining to the implementation of reparation programs, the marginalized areas. I'd like to thank those who are following us on Facebook. Tomorrow we shall meet again. Just to beg to please fill in the health protocol that you have inside the documents handed to you. So good evening to everyone, and we shall meet you tomorrow. Thank you very much.